sentencing. I've left these poor people here waiting, so. People against Kyla Ann Langley, file 25F243814OD. Good morning.
Good morning, Your Honor. Marissa Boyles, P86438, on behalf of Ms. Langley. State your name to the record, please.
Kylie Langley.
All right, so your client pled guilty to the added count of operating while impaired, and then the operating while intoxicated was dismissed. There was, I believe, agreed upon cost of recovery of $150. I referred her for a screening and assessment. Again, the OWI was dismissed. Have you had the opportunity to review the report? Are there any material additions, corrections, or deletions?
Yes, we have reviewed the report, Your Honor. There are no additions, deletions, or corrections.
Okay. Anything that you would like to say on Ms. Langley's behalf?
Yes, Your Honor. This was a first alcohol-related offense. She is employed. She's also engaged. She's complied with her bond fully. She's getting married in August, so she will be requesting permission to leave the state for that. But otherwise, she's complied with bond. She takes full responsibility for this, her actions. We do believe the recommendation to be fair, and I would ask that you abide by it, Your Honor.
Did you bring your AA verification today, ma'am?
I did.
Have you shown that to your lawyer? Counsel, I just want to make sure that she,
Absolutely, Your Honor. May I approach with it?
no, I don't need you to approach. You just tell me whether she's gone twice per week. That should be somewhere in the neighborhood of about 10 times.
There are 10 sessions on here.
Good
from
enough.
June 19th up until June 20th.
Good enough. What else would you like to tell me?
Your Honor, just that this was an isolated incident. She's taken steps to address it. She told me before coming up here, she does enjoy the AA meetings and she does plan to continue them. So, like I said, I do believe the recommendation to be fair. She's willing to comply with those requirements and is looking to just put this behind her.
What happened on the Disturb the Peace out of Florida from 2012? It says you were arrested for disturbing the peace.
Yeah, they let me go. It was for yelling at my husband.
Okay. And you were never charged?
Nope.
What about this resisting an officer charge out of the 20th District Court in 2011?
I don't remember that.
Well, you have a bench warrant out for your arrest.
I've never received anything and I've never even heard of it. And I've been arrested, like, they never said anything about it. I've never even heard of that.
You better check with them. I mean,
When I was arrested for this drunk driving, they never said that anything was on my record.
Jennifer, would you please, Lisa rather, can you hear me? Would you please check that? I don't see.
I can hear you. I'm sorry. What was that?
Wait a minute. Let me just double check here. Give me 1 second. Yeah, you got a Dearborn Heights resist and obstruct warrant from 2011.
I've never, and I've actually gotten
You
a
have to
ticket
go
since-
over and take care of that.
Okay, because I've gotten a ticket since then and gone to court and fight the ticket and they've never said anything.
All right. So I just want to be clear, you have that out, and whether you remember it or not, you have to go over to Dearborn Heights and clear up that warrant. You're to clear all warrants within 30 days.
Okay.
Okay, that's part of my probation order. Anything else anybody wants to say?
No, Your Honor.
Ma'am, anything else you would like to say?
No, sir.
12 months probation. You cannot leave the state without the consent of the court. I mean, you did have a high breathalyzer here. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs bi-weekly for 4 months. If you're clean, I'll make it then monthly.
Did you think bi-weekly, so I guess go twice a week?
No, that's once every 2 weeks. Bi-weekly,
Bi-weekly, twice a month, not twice a week.
bi-weekly,
Okay.
every other week. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. So Again, it's bi-weekly for 4 months. If you're clean, I'll then make it monthly. No kratom, no poppy seeds, no CBD oils. AANA, I want you to attend, continue to attending twice a week until you're in an outpatient treatment program. Once you get in an outpatient, you don't have to go to AA or NA any longer, okay? You're also to attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. Okay? 4 days jail, credit 1, serve 3. I'll let you serve those by community service. So I won't make you do the court work program, but I do want them done 24 hours by August the 10th. 24 hours, you can do that at any nonprofit organization, Salvation Army, St. Vincent de Paul, the church, Habitat for Humanity, animal shelters, you name it, as long as it's a nonprofit organization. Pay fines in the amount of $300, costs in the amount of $300, $75 victims' rights fee, $50 justice assessment, $60 screening fee. So your total there's $785. Probation fees are $240 for a total of $1,025, plus you have cost of recovery of $150 to be paid through the court. We will forward to Flat Rock. The total is $1,175. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. And also, I want you to understand, you are to clear all warrants, as I said, within 30 days. So you need to go over to Dearborn Heights, and you may be eligible, excuse me, for early discharge. You get everything done, no violations. Within 6 months, you'll be off probation. You just have to make the application. You understand all that? All right, high breathalyzer, please be careful. Do you have all of this money to pay, ma'am?
Yeah, I can pay it today.
So you pay this now, and then you will go over and meet with probation. I wish you well. Nice having you here,
Thank you.
counsel.
And Your Honor, just one more thing, make sure you have permission to leave the state.
Oh, yeah, I'm sorry. When are you going?
I'll be gone from August 7th through the 14th,
To go where?
Louisiana.
Can leave state. Is that that's for your honeymoon or whatever?
No, it's my wedding / honeymoon, yes.
Well, nice. Good luck.
Thank you.
You can leave the state between August 7th and August the 14th. Okay? Good luck. Thanks a lot.
Thank you.
Epic Property Management versus Jillian Carroll and Ryan Carroll, 2502381.
Good morning, Your Honor. For the record, Rania Haddad, PA 497 for the plaintiff.
Are the Carrolls here?
Your Honor, I've not had them check in on Zoom.
Okay, there was a second mailing paid for. You can go ahead and proceed with your default judgment.
So, Your Honor, it looks to me like looks like the balance has been paid and what's remaining is attorney fees and costs. I'm just verifying that on my records real quick. Yes, Judge, that's actually what I'm reflecting. It's like there's a $233 balance, but that looks like it reflects increasing costs.
All right, you want to give me the breakdown?
Yes, Judge, that would be rent to retain has been paid. And it's just the $223.56 remaining for attorney fees and costs. So that would be the total balance.
All right, so you can prepare a judgment, 22356. Writ date will be July the 3rd. Defendant failed to appear. This was scheduled for 9. It is now 9:49. Epic Property Management versus Lanina and Kanaz, Lanina Shields and Kanaz Lawson, 2502382. Are they here?
Your Honor, I've not had the defendants check in on Zoom.
Second mailing was paid for. You can go ahead and proceed.
Your Honor, plaintiff moves for default judgment for possession. Rent to retain is $1,043. Attorney fees and costs of $223.56 for a total redemptive amount of $1,266.56. We would be seeking a writ date of 7/3/2025.
How much are your late fees?
Late fees, Your Honor, are $50 in late fees.
And that's included in the 1,043?
It is, Your Honor.
It'd be helpful if you give me those separately. from now on. 1266.56 is the amount to be paid to save it from the issuance of the writ. And the writ date in this case will be July 3. Defendants failed to appear. So writ date will be July the 3rd of 25. Epic Property versus James Van Horn, Dustin Lefevre, and Ariano Chmielewski, 2502383.
Rania Haddad, PA 497 for the plaintiff.
Your Honor, I've not had defendants check in on Zoom.
You paid for a second mailing. You can go ahead and proceed with a default.
Your Honor, it looks like there is rent to retain of, looks like it's 50 cents, attorney fees and costs of 262.95. So the total.
Wait a minute, slow down. So I missed that first part.
It looks like there's 50 cents remaining with, in rent, and then the remaining is $262.95 in attorney fees and costs for the 3 defendants. So the total redemptive amount is $263.45.
The balance, the rent to retain is 50 cents. When did they
Correct.
pay this?
Correct, Judge.
When did they pay everything that brought it to 50 cents?
I am just looking for my ledger here. It looks like 383. The ledger is reflecting the balance of there was a $1,089.50 paid on June 11th, 2025.
And they owed 50 cents more.
They owed, yes, Judge, that is correct.
All right, and then they owe the cost. So 263.45 default judgment. Writ date on these defendants will be July the 3.
Thank you, Judge.
All right. Epic versus Terry Henderson and Jennifer Perkins, 2502384.
Rania Haddad, PA 497 for the plaintiff.
I have not had defendants check in on Zoom, Your Honor.
A second mailing was paid for. You can go ahead and proceed.
Your Honor, rent to retain is $525. Late fees for 2 months, the amount of $100. Attorney fees and costs of $223.56 for a total redemptive amount of $848.56.
Defendants failed to appear. Default judgment will enter. Writ date will be July the 3rd. The amount to be paid to save it, $848.56. Epic Property versus Brandy Blaz and Jerry Taylor, 2502385.
Rania Haddad for the plaintiff, PA 4927.
Brandy Taylor, Your Honor, or Brandy Blas and Jerry Taylor, sorry.
Where's Jerry Taylor at?
He's at work.
Okay, well, so he has to show up from now on. Ma'am, did you listen to and understand the rights?
Yes, sir.
Do you intend to speak to, or would you like to speak to a lawyer?
No, sir, I have the rent. I just have to go drop it off.
You have all the money?
Yes, I do.
How much is owed, counsel?
Your Honor, I am showing rent to retain of $2,095.
Do you have all of that?
Yes, I have to go and pick up another check. I have $1,500 right here with me. And I just have to stop at the bank and get another one for the remaining balance. My mom had a stroke over the weekend and I was supposed to drop it off on Friday, but I was
Jeez, I'm
stuck in the
sorry.
hospital.
So,
Thank you.
ma'am, counsel, the defendant, well, do you have any objection to just adjourning this to July 7 with the understanding she's going to pay this?
Your Honor, my only question is, sorry, Judge, I would just like to give the complete attorney fee with the attorney fees and costs, so she doesn't have to worry about a partial payment here without not
Correct.
necessitating a default, I'm sorry, a dismissal. So it would be rent to retain of $2,095. The attorney fees and costs are $223.50. So she would have to remit $2,318.56 to merit a dismissal, which I have no problem, Your Honor, adjourning this to get a dismissal.
Can you repeat that amount one more time?
2,318.
318.
56 cents.
Perfect. Got it.
56. So we're going to have to adjourn it, unfortunately, for 2 weeks because I'm not here next week. So July 7th, Lisa?
9 o'clock.
8:30, 9 o'clock, at 9 o'clock. But you pay that today, ma'am, and get that over with, and then
Yes,
we'll
I will.
discuss it. You won't have to show up, okay?
Oh, perfect. Thank you so much.
Have a good day. Thanks.
You
Epic
too.
Versus Caitlin Smith and Anthony Johnson, 2502386.
Ryan Haddad, PA 497 for the plaintiff.
I have not had the defendants check in on Zoom.
You can take a default.
Rent to retain, Judge, would be 1,000 and, sorry, Judge, $895. That includes $50, $100 in, I'm sorry, Your Honor, $100. It's Monday, Judge. $50 in late fees, $223.56 in attorney fees and costs. So the redemptive amount is $1,118.56. So we would be seeking that default.
Okay, slow down because you're losing me. I thought you said initially it was 1895. Start over. Give me your figures again.
It's rent to retain of $895.
895. I apologize. And then you've got $50 in late fees for 945, and then how much in costs and attorney fees?
So the breakdown is $845 in rent to retain, $50 in late fees, and then the $223.56 in attorney fees and costs. And the total amount of redemption is $1,118.56. My apologies today, Your Honor. My staff does not put the notes in there about the $50. You would like that, the late fees capped at 50. So I'm gonna.
Actually, I cap them at 70 now.
Okay, well, that's good to know.
Okay, so default judgment's entered. I just want to make sure we stay on that. 111856.
Correct, Judge.
With the writ date of July the 3. Do you have another case here?
I believe that's it, Judge. The other one would have been a dismissal, and I'm assuming that the court has received it and entered it.
What case was that?
The case
Judge, it's not on. Yeah, that was all we had for, so we already took it off and sent it to
Fair
you.
enough. Thank you.
Judge.
Have a great day, Ms. Haddad. Thank you.
Judge.
Bye now. Golden Management versus Stephanie Stiolano, 2502341. Ms. Stiolano, your name?
Good morning, Judge. Stephanie Stiliano.
Counsel?
Good morning, Your Honor. Stephen Debates, PA 1248 on behalf of the plaintiff.
All right. Ma'am, did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
You intend to apply for funding?
No, sir.
Counsel, how much is owed? Just the total amount right now and
Total
everything.
amount is $2,540. And we have tentatively worked out a conditional dismissal, if we could put that on the record.
Absolutely. Go ahead.
So we've got a conditional dismissal. Total amount again is $2,540. That is rent in the amount of $2,123, court costs in the amount of $267. Other money due is $150 for late fees with $50 a month.
Again, I just want everybody to know I raised those to 70 several months ago now. So
Okay.
if the contract provides for it. So what's your total here?
So it would be $150 if we're going to cap that at 70. Is that what you're saying?
No, I'm 70 a month. You got
Gotcha.
three late
So
fees.
the contract states that, so we're going to leave that as is.
So you got 2273 plus 267 for 2473, 2540 it should be. Is that right?
That's correct. That's the total.
All right. And then what is the rest of the terms?
Defendant shall pay $500 per week beginning June 27th and continuing in the same manner every week until arrearage is fully paid. Defendant agrees payments will first go to future month's rent, which is $810 per month, and late fee, which is $50 per month, before being applied to the back due arrearages listed under the amount in 2D under the conditional dismissal. If defendant defaults, the application or eviction and a judgment for the balance due at the case reinstatement time shall be entered.
So the $500 a week first applies toward future rent
That's correct.
and late fees and attorney fees and
Yes.
costs.
Yep,
And then the 500 per week will apply toward the arrearage.
that's correct.
Do you understand that, Ms. Stiolano?
Yes, I do, Your Honor.
Do you agree to those terms?
Yes, Your Honor.
Does he have your permission to sign your name to a proposed conditional dismissal that sets forth those conditions?
Yes, Your Honor.
Okay.
I also made 2 payments, one, June 12th and another June 19th, and I don't believe that was added into this total.
No, they were not. What were the dates on those payments
June 12th,
and the amounts?
$200, and then June 19th was $800. I paid online on the app or on the website.
So counsel, if that's the case, I want you to indicate on other orders, this does not include 2 payments made by defendant as follows: $200 on whatever date and $800 on the alternate date, on the other date.
Absolutely.
Okay?
All right.
So make sure you make clear, though, that those payments, if made, would reduce this balance to
I'll
15.
be very clear about that. I'll confirm with my client, but I have no reason not to believe Ms. Staliano, and I will make that very clear that those payments are not to be considered and will be deducted from the balanced amount.
Okay? Ms. Dialano, any other questions or thoughts?
No, I just had one minor complaint, but I talked to Jen about it last week about
What's that?
the process server. I was at work and he served my minor son the paperwork for my court date today.
How old's your minor son?
He's 15.
That's not sufficient. What's he doing?
All right. I don't know. He handed my son the paperwork and said, make sure your mom was in court Monday morning.
Hang on one second. Counsel, make sure you talk to the process server.
100%. Yeah, that's unacceptable.
That's not a person of suitable age. I mean,
No.
geez.
No, it was just, as a mother, I talked to Jen about it too. Just, you want to shield your children from this, and I was at work at the time.
I got it.
Yeah, I wouldn't want that either. I will definitely let that court officer know, Your Honor.
Yeah, and I was wondering if any process fees for that would be deducted. I mean, I'm very upset that my child had to endure that, especially with the process server saying, make sure your mom is at court on Monday. His words.
Who did that service, Jenna?
I'll double check. I think it was Phil.
I'm not going to waive the service fees, but we are going to talk to him, and we're going to make sure that does not happen again, Jennifer. Okay?
Yep, I will do that.
Okay, thank you very much. And how is your brother, Ms. Staiolano?
He's doing great, sir. Thank you.
Is he?
Yes.
Be sure you tell him I said hello.
Yes, I will. Thank you.
All right, he's staying clean.
He's staying clean, yeah. But just lost his job. They took everyone off the line at Brose.
Well, I'm very sorry to hear that. Please give him my best, okay?
Yes, sir.
All right, have a great day.
You
Thank
as
you.
well, sir. Thank you.
Golden Management versus Audrey Wynn, 2502355 is Audrey Wynn. Good morning, Ms. Wynn. Your name?
Audrey Wynn.
Mr. DeBates?
Stephen DeBates, P81248 on behalf of the plaintiff.
It's a great name for a lawyer, by the way.
Thank you, Judge.
Did you listen to and understand the rights this morning, Ms. Wynn?
Yes, I did.
Do you wish to speak to a lawyer?
No.
We didn't pick you up on that.
Oh, I'm sorry. No.
And do you intend to apply for funding?
No, I don't.
Counsel, how much is owed?
We have a total of $3,928.43.
Can you pay that, ma'am?
I actually made 2 payments to Tracy for adding the amount.
I don't know what that means.
I made a $500 payment.
They got to tell you guys when they do that. Will you make sure they do that, please? I don't want to have to go through this worrying about them getting credit or not getting credit when they should or shouldn't get credit. They need to communicate that to you.
Yeah, I'll follow up with my client on that, Judge, about.
I know, but now I've got, when did you make your payments?
I made the payment on the 22nd, and I made the
2nd of June?
Yep.
Yesterday.
Yesterday.
$500?
Yesterday I made a payment of 200, and then Friday the 20th, sorry, my bad. The 20th I made a payment of 300.
For a total of 500, you're saying?
Stay right there.
Yeah,
I'm
the
gonna,
total
I'm gonna go
500.
ahead and I'm gonna ask you to call your client and get them in here. Will you do that, please? The management company?
Yeah, I can do that, Your Honor.
I'm gonna go on to another one. Golden Management versus Reno Wesley, 2502356. Is Reno Wesley out there?
Yes, sir. Yes, sir. Good morning, Your Honor. I'm having some technical difficulties.
You have to start your video, sir.
Alrighty. All right. There we go.
There you go. Good morning. Your name?
My name is Reno Wesley.
Did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
Is there a court-appointed one available I can speak with?
Yeah, well, it's from Lakeshore, and we can give you a lawyer.
Sure, Your Honor.
Are you applying for funding?
Yes, I did. With DHS.
All right. When did you apply?
It was about a week ago.
All right, listen, here's what we're going to do. I'm adjourning this to July the 7th, Jennifer, at what time? I'm going to say 9 o'clock. You're going to stay where you are, and we're going to put you in a breakout room to speak to a caseworker from Lakeshore, and then you need to follow up with Lakeshore in the next day or two. Okay?
All right.
And
Thank you,
also, you need to submit your application for funding. You have to bring that to the court within 5 days. Okay?
Okay.
So bring that up to the court within 5 days. Lisa, I don't know, maybe you can communicate to Jennifer to set him up put him in a breakout room with the Lakeshore case manager, okay? That's where we'll do it. Counsel, I'm going to move on. So, sir, be back July 7th at 9. Counsel, I'm going to ask you to get your client in here on Audrey Nguyen. I'm going to go on to another case, and we will go there.
That's fine, Your Honor. I've reached out. I've got no problem consenting on behalf of the client in regards to the 500 payment if we want to move forward right now to keep things moving.
It's up to you, but if I do that, then as far as I'm concerned, whether she paid it or not,
that's fair.
Start with it. Okay, go ahead. But they can't emphasize enough. They've got to let you know when payments are made. I don't want to go through this every Tuesday. All right, go ahead. Tell me what's owed.
Yep.
So now you've got 342843, right?
That's correct, Your Honor.
Give me your breakdown.
That would be rent in the amount of $3,053, late fees in the amount of $150, and court costs in the amount of $225.43.
So the total again, 342843, right?
That's correct.
All right, so that will do that, ma'am. Your writ date, though, I'm going to do this as a judgment after hearing. Your writ date will be July the 3rd. So you have to pay, Ms. Nguyen, you have to unmute and state your name again. There you go.
Audrey Nguyen.
So you're going to have to pay this by July the 3rd. Do you understand that?
The whole amount, or is there a possible way I could make an arrangement? Because I do have math written out of when I could make the payments, and I could pay it all off by the end of August. If not sooner, because I am getting a raise in my job in the beginning of July.
That's up to you guys. You want to go into a breakout room with her?
Your Honor, if I could request a short-term adjournment, and then I can figure out the payments and we can work on a payment plan and hopefully send a consent judgment or CD to you prior to the next hearing.
I can't do it. I can't do it with I don't want to do she's unrepresented. So consent judgment has to be in open court, as does a conditional dismissal. So I'll adjourn this to July 7th at 9 a.m. You can confer with her and you guys can come up with a payment plan. Okay?
Thank you very much.
But you're still going to have to be here in person, ma'am. Good luck. Thank you.
Thank you.
DeLon, Cassie Rose, Mary DeLon, 24T708-513FY.
Good morning, Judge. Mezzagate from Ms. DeLon.
All right. Ms. DeLon, your name?
Morning, Judge. Can you hear us?
I can, Detective. Your name?
Detective Sergeant Mark Driscoll, Trent Police.
Ma'am, your name?
Cassie Delon.
You don't have one with her, do you, Lieutenant Mercure?
He's got two sides.
Okay. Well, counsel, what is she going to do? She was supposed to be here a year ago, April of 24. I revoked her release, forfeited the bond due to failure to appear and test weekly, as I ordered. Told her she had to appear immediately for arraignment. She didn't.
I did explain all that to her, Judge. She's going to be pleading guilty with an explanation.
Well, I don't really even need to deal with that. I'm going to arraign her on the charge here, which is a one-count complaint for possession of cocaine.
Wasn't she already arraigned, Judge, back on
She was arraigned,
April 24th?
but I'm going to do it again since it's been a year.
Okay.
So does she stand mute?
We'll stand mute and waive it, correct.
Ma'am, I'm going to explain your rights to you again. You're charged with a 4-year felony possession of cocaine. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference, Lisa, I just want to make sure, give me another bond sheet, please. You've got this set for 9:30 in the morning on July 1?
Yeah, you're not here that day, so Judge Hessen will have to handle it.
And then July 8th at 1 p.m. That
Yeah.
will be in front of me. Okay, ma'am, do you understand that?
Yes, I do.
Do you still live on Marion Drive?
Yes.
Same unit?
Yes.
All right, counsel, what would you like to say regarding bond?
Judge, taking into consideration Ms. DeLon's past history, we would still ask for a personal bond. Ms. DeLon's failure to appear, honestly, Judge, was caused by an abusive relationship, an abusive ex-boyfriend that she was living with. He was both physically and emotionally abusive to Ms. DeLon. He would beat her almost on a daily basis. He would lock her in the house. Every time she got a phone, he would break it. That's why on the hour away, there's a note that there were several calls made. There was one line was busy, the other one had a full mailbox because she wasn't able to communicate with anyone. It prevented her from working, Judge. So it was, and she just got out of that relationship, so she's trying to put her life back together. Ms. DeLon also suffered as a result from PTSD and other mental health issues. She understands she has a problem, Judge. She's willing to go to treatment. She understands that she's got to make some affirmative steps here to help herself before the court would be willing to show her any type of discretion. We asked the court for a personal bond in this matter, Judge. She hasn't been able to work because of everything that's been going on. So her finances are limited. And looking at her criminal record, Judge, aside from two other issues relating to possession or drugs, she does not have a significant criminal record. Yes, the court may see her as a flight risk, but she assures me that moving forward, she's going to make 100% effort to be here and resolve this issue. Isn't that correct, ma'am?
Yes.
Detective, anything?
Your Honor, we'll leave it to your discretion. I'm sure you're aware, just so the record is noted, that she does have a warrant out of Wayne County. It's no bond warrant. So just so you're aware.
Ma'am, you live right down the street. I usually hear I can't get a ride. And I just don't go for this. I'm sorry that you were going through that. I hope you were making police reports. If everything that Mr. Gates just told me is true, your ex-boyfriend or whatever, the abusive relationship that you had to undergo. He should have about 10 or 20 criminal complaints for domestic violence filed against him. 35,000, 10%. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. No alcohol, no marijuana, no illegal drugs. AANA 3 times a week, and you do have to test weekly. And I do have to know that you violated the bonds repeatedly. I revoked the release, forfeited the bond pending a hearing. You asked them to call and set you up for arraignment. You just didn't show up on any of these things. Your first court date here. And again, if you post that bond, you come into the court that day, and have probation set you up for weekly testing. If you don't post, we'll see you July 1, and that will be at 9:30 in the morning. Good luck. Thank you very much. Have a good day.
Thank you, Judge. Have a good day.
Close out a petition and give her another court AA sheet, will you please? Philip Russell.
Yes, Your Honor. I'll get it to her.
Thank you. Philip Russell Conklin.
Would you consider on the
No,
put on a tether?
no. Thank you. Sometimes we get stuck with cases that we can't win, right?
Thank you.
Philip Russell Conklin, 250-713-371. Your name, Lieutenant?
Detective Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear affirm under the penalties of perjury the testimony given these proceedings will be the whole truth, self you got.
I do, Your Honor.
All right, go ahead.
Your Honor, on 5/11/25 at approximately 2:45 in the afternoon, Officer Stephen Corn of the Rockwood Police Department was dispatched at 21722 Huron River Drive within the city of Rockwood for a felonious assault complaint that had just occurred. Upon Officer Corn's arrival, he spoke to the victim, Johanna Lopez. Ms. Lopez stated that she was having a conversation with Philip C.'s girlfriend, CJ, regarding Mother's Day dinner. During the discussion, an argument ensued, and as the argument escalated, CJ became aggressive towards her. At one point, he threatened to kill her. CJ then pushed Ms. Lopez up against the wall, pinned her with one hand, and with the other hand, he retrieved a knife out of his pocket and held it to her throat. At that point, she was threatened that she was going to get cut or harmed. As the argument continued, she grabbed her cell phone and called 911. At that point, Philip left the residence and took off on foot from the scene on location. Officer Corn then spoke to Philip's mother. Her name is Lisa Summers, and she identified her son as Philip Russell Conklin, white male, 9'3" of 87. And Officer Corn was able to confirm the identity of him through the Michigan Secretary of State. When it comes to convictions, Your Honor, all the 3 convictions he has are on December 19th of 2007, and they are all out of the Lane County Circuit Court in the state of Oregon. One count of the offense of theft, first-degree larceny. Second one is burglary, first degree. And the third one is a felon in possession of a firearm. I submitted a warrant to the Wayne County Prosecutor's Office. You have a charging document in front of you.
Based on your sworn testimony, I find the crime felonious assault was committed. There's probable cause to believe the crime was committed by the defendant. Also that he has 3 prior convictions, as you testified to, giving rise to the habitual offense. People against Cody Snyder. Are we okay?
We're okay. Shane had to move some.
That's okay. 250-706-513. Lieutenant, your name?
Detective Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Your Honor, on December 29th, 2024, at approximately 3 o'clock in the morning, Officer Freddie Harshbarger and Officer Christopher LaFleur, both of the Rockwood Police Department, were dispatched at 20306 Huron Drive, Apartment 11, in the city of Rockwood, regarding a possible home invasion domestic. Upon arrival, Officer spoke to Lauren Weinstein, who stated that she had some people over to her house that evening in question, and that her ex-boyfriend, Cody Snyder, was calling her. Should be noted that they had been broken up for approximately 3 months, and he currently does not live at the residence. Lauren stated that Cody kept calling her, so she shut her phone off. After shutting her phone off, a little while later, Cody showed up at her apartment and started kicking the glass sliding door. At that point, Lauren had her friend, Kevin Shepard, go upstairs to avoid any confrontation. As Cody kept kicking the door, he then retrieved a hidden key that was outside the apartment where Cody knew it was at because he used to live with her. Unlocked the door, entered the apartment, went over to the utensil drawer in the kitchen, grabbed out a unsure item at that point, and then started to run upstairs to look for Kevin. As he was running up the stairs, Lauren tried to block him from going up there. He grabbed her by the hair and threw her to the ground. As they were fighting, Kevin noticed that he had what appeared to be a hunting knife in his hand. So he ran out down the stairs and outside the apartment with Cody chasing him with the sharp object in his hand. He was able to get away and the police were called. I sent a warrant to the Wayne County Prosecutor's Office.
It says scissors. Was it scissors or?
Well, she said it was scissors. He said it was a knife. Lauren said it was scissors. So I'm not sure if he grabbed two things out of the drawer, but he described it as a hunting knife. And then Laura described it, it looks like scissors. But the officer did recover a set of scissors.
I'm going to just add on the complaint and or knife. Okay?
Yes, Your Honor.
I'm going to add that on both the complaint and the warrant and count one after the word scissors and or knife. Jeez. All right. Give me 1 second. And I'll note that you signed the complaint, court assigning and dating the complaint and the warrant for the arrest of the defendant for domestic, felonious assault, and illegal entry without permission. You're all set. Thank you very much. We'll get these into lien. Thank you. Golden Management versus Audrey Nguyen. Did you adjourn that? I'm sorry. Williamsburg versus Trevor Kimes and Victoria Smith, 2502357. Do I have Trevor Kimes or Victoria Smith? Ma'am, your name?
Victoria Smith.
Sir, your name?
Trevor Kimes.
All right, and Mr. Smith.
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of the plaintiff Williamsburg Square. This is a non-payment or rent possession only matter. This is our first hearing.
Mr. Kimes and Ms. Smith. Let's start with you, Mr. Kimes. Did you listen to and understand the rights?
Yes, sir.
Ma'am, did you?
Yes, sir.
Do either one of you wish to speak to a lawyer? Mr. Kimes, rather?
No, sir.
Ma'am?
No, sir.
Either one of you intend to apply for funding?
No, sir.
No, sir.
All right. Mr. Smith, tell me how much is owed.
Your Honor, at this time, the total in rent, the total amount owing is $1,065. There is $170 late fee. The bailiff fee, filing fee, court fee total $83.43 and $63. The total amount of those costs is $1,356.43.
Do you agree that you owe that amount, Mr. Kimes?
Yes, sir.
Ms. Smith?
Yes, sir.
Can you pay that, Mr. Kimes or Mrs. Smith?
I can have it Monday.
Mr. Smith?
That'd be great, Your Honor. I would ask the court to enter a writ, which wouldn't be till July 3rd. The hope is they can come and pay and we can dismiss this matter.
Yep.
So I want you to understand that he's essentially asking me for a judgment.
Yes.
So if I grant that, that means you'd have until July the 3rd to pay up or vacate. If you don't do either one of those, you'd be evicted. Do you understand that, Mr. Kimes?
Yes, sir.
How about you, Ms. Smith?
Yes, sir.
All right, so council, the total amount owed is 1356.43. Does Mr. Smith have your permission to sign your name to a proposed consent judgment that sets forth those terms and that you owe 1356.43 and have to pay up or vacate by the 3rd of July? Mr. Kimes?
Yes, sir.
Ms. Smith?
Yes, sir.
All right, so he's going to sign your name. We're going to get the judgment out to you, hopefully today or tomorrow at the latest. And you just have to know that you have to pay up or vacate by the 3rd. Also, you have 3 business days, since you're unrepresented by a lawyer, to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal. Do you understand that, Ms. Smith?
Yes, sir.
Mr. Kimes?
Yes, sir.
Any questions at all for me?
No,
Either
sir.
one of you? All right, good enough. That's what we'll do. You're all set. I wish you both well. Good luck to you. Thank you.
Thank you, sir.
Thank you.
Have a nice day.
You too. Williamsburg versus Sierra Thomas, 2502358.
Your Honor, I've not had Miss Thomas check in.
You can take a default on this. Go ahead.
Your Honor, the plaintiff is asking for a default judgment. The total amount due and owing is $2,692.53. That's broken down. Rent totaling $2,375.99. 2 late fees of $70 totaling $140. Bailiff fee, court filing fee is $70.04 and $31.50, totaling $2,692.53.
Defendants failed to appear. Default judgments entered in favor of plaintiff against defendants. The writ date in this case will be on July the 3rd. Williamsburg versus Santia Prather, 2502359. Ms. Prather, start your video. State your name.
Santia Prather.
Good morning, ma'am. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No, thanks.
Do you intend to apply for funding?
No.
Counsel, give me the total, just total balance that's owed.
Total balance is $1,521.54.
Do you agree that you owe that amount, ma'am?
Yeah.
Can you pay that?
Is that for May or is that for this
That
month?
it includes June rent, right, counsel?
Yes, Your Honor, it's 2 months, May and June.
Right.
May is already paid. I already paid May.
Ms. Burns, good morning. Your name?
Good morning. My name's Jessica Burns.
Did she pay May?
Let me bring up her account here. Just one moment.
Prather, when did you make that payment?
Like a couple weeks ago, maybe like 2
Yeah, it
weeks.
looks like on June 10th.
She made the May payment?
Yes.
So how much, how much do you think that she owes?
Alright. Currently, I show $1,461.54.
Oh.
Oh,
Well, boy, you guys are off. What's the monthly rental rate?
yeah, Your Honor.
1,275.
All right, so they agree that you paid May rent, but they think you owe 1,275 for June rent, plus the other figures here would amount to
Court costs, filing fee.
court costs and statutory attorney fee for a total of 1,464.54. Do you agree that you owe that amount?
Yes.
All right. So
Sorry
what do
about
you? So let's give me the breakdown on this, please. I've got 1245 in past due rent. Any late fees?
One late fee of $70.
Okay, and then how much in filing and service and
$70.
you can just add them all up.
Okay, sorry, $101.54.
All right. Do you agree that you owe all that, ma'am?
Yes.
When can you pay that?
I don't get another check until the July 8th, but it's really not. It wouldn't actually be enough to cover the whole cost. So I could pay on it. Like I could put what I'm gonna have on it.
What do you guys want to do?
Your Honor, at this point, I'd ask to enter a judgment, and if Ms. Prather wants to work on a payment plan, we're more than happy to work with her, but we need that judgment for assurance.
Ma'am, I'm gonna give him a judgment after hearing for 1464.54.
Okay.
I'm gonna say that if you pay, and you can add this, if you pay $850 by June the 3rd, that the writ date will be extended until July the 11th.
Wait, did you say pay by June 3rd or did you mean July 3rd?
July 3rd. If you pay $850 by July 3rd, if I misspoke, my apologies, writ date will be extended until July 11th. So that if you pay $850, you would only owe $614.54, and that will extend the writ date all the way until the 11th, but you have to pay the balance on that by the 11th. Do you understand that?
Yes, I understand.
Okay, do you have any questions?
Nope, I'll be paying it.
All right, I wish you well. And does Mr. Smith have your permission to sign your name to this judgment? I'm going to do this one after hearing. So does he have your permission to sign your name to that proposed judgment?
Yes.
Actually, yeah, let's just do it after hearing. You don't need to sign her name.
Okay, thank you, Your Honor.
She'll submit it. He'll submit it. I'll sign it. And you just make sure you write those dates down. Okay, ma'am?
Okay, thank you.
I wish you well. Anything else, Mr. Smith?
That's all I got. I saw, off the record, John Kennedy Sr., I think, is your cousin, if I don't mistake correctly.
Yes.
Saw him Saturday night, him and Jim Kennedy and a bunch of their family, and he told me to tell you hello if I run into you. So.
Yeah, give them my best. I only see him seemingly at funerals. It's terrible.
I know,
Good
right?
people.
Right. All right.
Give them my best. Thank you.
Will. Good seeing you.
Thanks.
Take care, Your Honor.
All right, Kathy Josephine Wilder Kiss, 25B722945. Have we called Brownstown?
Yes, sir.
All right.
Ready, Your Honor.
Good morning.
Good morning.
Your appearance?
Thank you very much, Your Honor. Attorney Thomas, Court P77177. I'm here on behalf of the defendant. Do you say your name for the record, please?
Kathy Wilder.
All right, what are we gonna do on this? Does she stand mute, wait formal reading?
Yes, Your Honor.
All right. I'll enter a not guilty plea. Ma'am, I'm gonna advise you of your rights. Detective Morrison, your name?
Detective Sergeant Morrison, Brownstown Police Department.
Ma'am, you have the right to remain silent. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that? You got to keep your voice up.
I do.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by your lawyer at that questioning. Do you understand that?
Yes, I do.
You have the right to a probable cause conference within 14 days, the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, the people will have to show that the crime was committed and that you were the one who probably committed the crime. This is custodial interference, kidnapping, a 1 year and 1 day felony. Do you understand everything I've said?
Sir, what is 1 year?
Okay, I'll talk to you about that in a second. I will. Let me tell you this. Pre-CC will be July 1 at 9:30. Preliminary exam will be July 8th at 11:30. Anything basically punishable by, for the most part, there's a couple of crimes, but anything punishable by more than a year is a felony. They charge this by as a 1 year and 1 day, making it a felony as opposed to a misdemeanor, which it would be if it was a 1 year. So they've got the extra day. Do you understand that?
Yes.
Okay. So probable cause conference, July 1 at 9:30, preliminary exam, July 8 at 11:30. Those will be in front of Judge Hessen. So I need you to remind me on this one a little, Sergeant. I know I only did this a month ago, but tell me real briefly what happened.
Yes, Your Honor. So there was a custody between both parents. There were some allegations. CPS was involved, going both ways, and basically, Miss Yes refused to turn her son over to the father. He made some complaints, and so we sent that in to, the father did end up getting his son back though. And there haven't been any complaints since, to the best of my knowledge. So I believe that Miss Wilder Kiss was, from what I was told, she was in some sort of custody downtown. I believe that she was charged or arrested and put in jail for something down there for contempt, but I don't know this particulars behind that.
Yes, Your Honor. Basically, the child reported being sexually abused by the father. A doctor signed an affidavit saying that he believed it was true. Ms. Kiss at that point allegedly refused to return the child. The judge downtown said, return the child or go to jail. Ms. Kiss did do a number of days in jail. This was months and months ago. She's been released by the judge from contempt. The child is now only having supervised visits. I believe 10 visits have already occurred, roughly, Your Honor, with no incident.
Supervised how?
At a location appointed by the court.
Where?
You know,
On 4th Street in Wyandotte, downriver, counselor, downriver.
So you just meet the child there?
Yes, I do.
Is the child otherwise in the custody of Mr. Joseph Wilder?
Yes. Still shared joint custody.
But he doesn't have supervised visitation, just you?
Just me.
Well, I just want you to know, we're not going to get along very well if you violate orders. Do you understand what I'm saying to you?
Yes, sir.
What are you asking for, counsel?
Thank you, Your Honor. I would ask for a personal bond in consideration that my client has no violent criminal history. When she was 20, roughly, in Florida, she got in trouble for indecent exposure. But besides that, Your Honor, no criminal history. She also, as for being a danger to the public, only risk could be alleged to be her child, but the Circuit Family Court has put something in place. And those visits, we've had a review after those visits, and they've recontinued with no incident, Your Honor. So I ask that the court consider a personal bond.
What are you asking for there, detective?
Your Honor, nothing. I'll just leave it at the court's discretion. Like I said, since this thing kind of kicked off months ago, it seems like things have been pretty quiet. And if the court has put measures in place that are being followed, I have nothing to add.
$15,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any circuit court order with respect to visitation. So if the order is supervised visitation, that means it's to remain as such. If you took that child and left the state, we are going to have a big problem. You cannot have any contact with prosecution witnesses except through your lawyer. Again, you cannot violate a law. You must appear in court as directed. I'm not going to order a GPS tether because if I do, you're going to be sitting in the county for 6 days or 5 days until they can fix it. But I'm telling you, I hope you take me very seriously. Do not remove that child. Do we understand one another? I can't hear you.
Yes, sir.
You also have to go over to the Brownstown Police Department to be fingerprinted and photographed by 1 p.m. today, okay? We're going to give you an order. We're going to give you your bond condition. We're going to give you your notice. And that's it. Anything else, counsel?
No, Your Honor.
All right. Thank you, detective. Have a good day. Good luck, ma'am. You're going to be in front of Judge Hessen when you return on those dates. Thank you. Baldwin House versus Chris Gross. 250-2215. Good morning, Howdy. Your appearance.
Plaintiff.
Is Chris Gross out there? I don't see him. Oh, your name, sir?
Chris Gross.
You spoke to a lawyer. Is a lawyer from Lake Shore going to represent you?
I don't know.
Do I have anybody from Lake Shore that has entered an appearance on this?
No, Your Honor, I don't have anyone.
All right, so
I talked to the lawyer and I got my phone now. So she asked me to try to set up a payment program
Well, this isn't for,
I understand that.
this is not for non-payment of rent. This is for.
I understand that.
Mr. Gowdy, do you want to go into a breakout room with him and see if you can resolve something on this?
Yeah, I'll do that. That's fine.
Let's do that. Let's put this gentleman, you go speak to this lawyer, Mr. Gowdy. And then either way, you're coming back in front of me, Mr. Gross. Do you understand that, sir?
Today, come back in front of you?
Yeah, you're gonna go speak to him. He's gonna take you to a computer, okay?
All right, thanks.
Thank you. Marsh Creek versus Tamika Jones, 2502220. Is Tamika Jones here? Doesn't appear so. You can go ahead and take a default, your appearance.
Good morning, Your Honor. Jeff Gowdy on behalf of plaintiff. We request a default judgment for defendant's failure to appear.
You can go ahead and proceed with your figures.
Your Honor, rent to retain possession is $3,910, cost of $170, total judgment $4,080. That would need to be paid in full by Thursday, July 3rd, or writ.
What is the late fees?
We had 2 late fees at $100 per month.
I don't give those, you know
I
that.
forgot about, let me back, I'll back out.
I'm gonna ask you to be very careful with that if you would, okay?
Sure.
So you got 3710 and past due, rent. 3710 and past due rent and 140 in late fees, right?
Judge, I'd ask for a $50 late fee per month for those.
Well, I give 70.
Oh, you do? I didn't know you gave 70. All right.
Yeah. So you've got 3710 past due rent, 140 in late fees. That's 3850.
Gotcha.
And you got $170 in cost for a total of
4,020,
right?
Correct.
Default judgment will enter. Writ date will be July the 3rd. You can submit that today if you would, please. Marsh Creek versus Ashley O'Neill, 2502224.
Good morning, Your Honor. Jeff Gowdy on behalf of plaintiff.
I don't see Ms. O'Neill out there. Is Ms. O'Neill out there?
No, Your Honor, I've not had him check. I had her check in.
Default judgment if you want.
Thank you, Judge. Give me 1 second. Sorry.
Take your time.
Looks like I've got late fees of $210. That's 3 months. It's $70 per month. Rent of $1,641. Plus 170 in fees. Equals $2,021.
Defendant failed to appear. Default judgment will enter. Writ date will be July the 3rd. The amount to be paid to save is 2021. Marsh Creek versus Tyasia Pool, 2502225. Your name, ma'am?
Tyasia Pool.
Good morning.
Good morning.
We adjourned this and the balance was 1853. Where do we stand on this now, Mr. Gowdy? Your appearance?
Good morning, Your Honor. Jeff Gowdy on behalf of plaintiff. I'm still showing a balance of 1853.
All right. Why don't you give me the breakdown?
Judge, and I believe that 1853 includes, it does include $100. There's 4 $100 late fees. So if I back that out.
Give me the rent to retain first.
1283.
1283, and then you have
I'm sorry, Judge, I did that wrong.
So now you have 4 months at 70 for 280. That makes it 1563. How much do you have in service, filing, and attorney fees?
$170.
$1,733. Is that what you're getting? Should be.
Yes, that's what I got.
Default judgment. I'm sorry, Ms. Poole. Do you agree that you owe that amount?
Yes, and like I asked you last week, can I get till just the 4th of July, and then I'll pay it all. It'll all be paid.
Counsel, I'm going to give her until the 7th rather. That's a Monday. You make sure you pay that off by then, okay?
Okay.
You have to pay $1,733 by July the 7th. This will be after hearing. Judgment for plaintiff after hearing. Writ date will be July the 7th. And as long as you paid that amount, $1,733, you can stay. Otherwise, you have to vacate, okay?
Okay.
I wish you well, ma'am. Anything else, Mr. Gotti? Well, I'll keep this here for you to speak to,
Mr. Gross.
Mr. Gross, yes.
Judge, I'm sorry, I was in a breakout room. Is he going down to get placed on a device?
Yeah, John was
Okay.
taken to someplace. Okay, thank you.
Thank you, Judge.
Thanks. Stephen Charles Bailey, 25W8384368 and B and C.
Good morning, Judge. Mazin David here on behalf of Mr. Bailey.
Mr. Bailey, your name? Where's Mr. Bailey?
He's on Zoom right there.
I'm not gonna let him appear by Zoom.
He lives in Ohio.
Where is he? Is this him on G-Power?
That's him right.
The
Mr.
Motorola.
Bailey,
Yes,
Mr.
sir.
Bailey, you have to tell me your name.
Stephen Charles Bailey.
Well, listen. Listen. Listen to me.
Yes, sir.
You were supposed to be here April 30, you didn't show up. You were supposed to be here May the 14th, you didn't show up. You showed up May the 21, you appeared, you signed in as Samsung and wouldn't answer any messages. We advised you to move to Zoom in on May the 28th and you didn't show up. Then we scheduled it for June 11 and you didn't show up. Listen to me.
Actually, he was here on the 11th, Judge. He had pneumonia. He said he signed in.
Well, come on. I mean, how many times you could, hang on. Where's Springfield, Ohio?
125 miles south of you.
Listen,
Yes, sir.
if we move all cases this slowly, we're going to have to build a 10,000 square foot addition to put our files in. I'm giving you one last chance. You miss again, I'm going to make you come here in person every time. Do we understand one another?
Yes, sir.
If you miss again, I'm going to make you come here in person every time. I want to make sure you understand that because you're not doing very good here. They're only going to pay you $17 million a year. You're about 1 for 5 here if you're a baseball player. Now, I'm telling you, this is it. And you have to get your device named Stephen Bailey. We got hundreds of people zooming in here every morning. We don't have time to ask everybody 17 times what their name is.
Okay.
Lisa, give me one last arraignment pre-trial. I'm telling you, you miss again, I'm going to make you come here and you're not going to like to deal with me. I'm telling you right now. Do we understand one another?
Yes, sir, I do.
100%?
Yes, sir.
All right. Give me a new arraignment pre-trial date on these.
June 25th at 10.
June 25th, 2 days. You're going to be here at 10 o'clock. If you don't know how to put your name on there, you get somebody to show you. Don't show up as Motorola or Samsung or whoever else. You got it?
Yes, sir, I do.
All right, good. You show up, I'll be easy to deal with. You keep playing with me, I'm not easy to deal with. And that I will not apologize for. Good luck. We'll see you here on the 25th. Owner's Management versus Justin Spicer, 2502423.
Good morning, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management. And I have to apologize to Ms. Spicer. I have a typo in the paperwork. Ms. Spicer's name is Justice Spicer, not Justin Spicer.
Okay, Ms. Spicer, your name?
No, it's Justice.
No, I know, but okay, you got to start your video.
Hi.
There you go. How are you? Your name?
I'm okay. How are you?
Good. Your name?
Justice Spicer.
All right. Okay, so we're going to amend the complaint. Amend complaint. Defendant's name to be Justice Spicer. That's a good name to have if you're coming to court. You know that?
Thank you.
All right. Ma'am, did you listen to and understand the rights this morning?
I did.
And you wish to speak to a lawyer?
Yes, please.
Do you intend to apply for funding?
Your
Is
Honor,
this
if I may,
termination?
yes, it's termination.
Yes, it is. Okay. So ma'am, I'm gonna adjourn this 2 weeks to July the 7th. Jennifer?
The 7th, yes, Your Honor. We can do that at 9:30.
At 9:30. We're gonna let you stay there and you are going to speak to the lawyer.
Yeah, I would like
Okay.
to do that before they just try to make me leave because I do want to state my case because.
Well,
every
we're
time they're
not
trying
to
make me
that
leave.
point yet, but they think you threatened, intimidated, and harassed another person in violation of their rules. And
They
wait, I'm not saying it's true. That's what they allege. And that they want you to leave because of that. So that's what you're up against. So you speak to them, Lakeshore, explain everything to them, come back on July 7th at that time, and then we'll talk about this.
Okay, thank you.
Okay? All right, so again, that's July the 7th. You can appear by Zoom again at 9:30. Any questions?
No,
Mr. Lechner, anything else?
No, Your Honor. Thank you very much.
Thank you. Good luck, man. We'll see you on the 7th.
thank you.
Mr. Gowdy, have you had a chance yet to speak to Mr. Gross? Probably not.
No, the tablet apparently keeps spinning. He's having trouble getting it
Shane
connected.
Pruitt, why am I looking at a?
He's
Mr. Pruitt,
on the on the Baldwin House versus Gross case. He's part of Baldwin House.
Mr. Pruitt?
Okay, I'm unmuted. Hi, Your Honor.
You're not driving. You wouldn't be driving. You would know how dangerous that is, and a judge shouldn't have to tell you that. So pull over.
I'm in a parking lot, so it's.
You're driving. Let me see your car. Let me lower that. Lower that.
I'm out.
Stay right there. Do not be driving. I'll be out as soon as they're ready. Stay seated, everyone. Recalling Baldwin House versus Gross, 2502215. Mr. Gowdy,
Your Honor, Jeff Gowdy on behalf of plaintiff.
your name, sir?
Chris Gross.
Did you two talk?
We did, Judge. We've reached a proposed consent judgment.
Okay.
This is a termination of tenancy. The term is that Mr. Gross has agreed to vacate the unit by July 3rd, 2025.
Is that true?
Yes, sir.
You agree to move out on her
Yes,
before
sir.
that date?
Yes, sir.
Does he have your permission to sign your name to a proposed consent judgment?
Yes, sir.
That calls for you to vacate no matter what is paid or not paid, no later than the 3rd of July.
Yes, sir.
And you understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, sir.
Do you have any questions?
No, sir.
Okay, counsel, you can submit that. Writ date July 3. Is that it for you, or do you have any more?
That was it. Thank you very much, Judge.
Have a great day, Mr. Gowdy. Good luck to you, Mr. Gross. Thank you.
Thank you, Your Honor. Have a good day.
I think that's it for all the rest.
Judge, we have Mr. Mayers at 11:30.
Oh, geez.
Yeah, we had some come off at
That's fine.
10:30.
All right. What else do I have? Is that the,
There's the return of the small claims, Mr. Hicks versus Bates Chevrolet.
yeah.
Yep.
Where's that file?
It's 11:30, Your Honor.
Okay. Okay. Tabitha, did I give you notes for that? Did I give you some notes? Maybe I gave you notes.
Are those the notes right there? I can print you mine.
All right.
What was that, Judge? What was it?
These are, I believe.
Okay.
I believe those are them.
Okay, perfect. Yeah. Do you want mine?
Sure. Tabitha, I need on this one case, the one, this one, it's coming back July 7th. I need to research that. Research issue money damages. Or no personal service.
Got it.
But second mailing. All right. I'll be back out. Stay seated, everybody.
Yes.
Find that you have pleaded guilty.
Who's watching the shot up there last year?
Actually, this is one of the older ones now.
Yeah, it
These
is.
didn't used to be the oldest, and now we're reeling all that stuff down, and it's good.
I don't think I have anything.
All right, that's gonna be.
We'll get it done.
First, remember, we got July 4th coming up. now.
Right, the first.
What day of the week is that?
So I was surprised. So it'd be the.
Okay, is that following Monday then, 7th?
In his email to us, he said he was back in July, and I know the other detective is back in July.
Okay. All right, well, on the 7th. Man. What else? Great.
Their jury's here tomorrow, so we'll have time to make sure we can answer.
You're a main reader.
Good morning,
Hello, ready?
No, sir.
It's 1,127 days and you're not ready?
Judge, I have a motion for production.
When? Okay.
He told me
That
about
was
this
filed
last
in
week.
6/9.
He told me that he's
1,200 days into this?
Yes, sir.
I'm railing on, but why?
I recently found out, like in the last month, about this particular facility. I need the records. It is my duty, Your Honor, to obtain.
Well, I know, but it's 1,200 days old, Joe. I mean, I'm not, you're telling me on the day of the trial, you just filed the darn thing in the 9th. I'm railing on, but I mean, it's.
We could just do like
1,100
a 4-week reset or so.
Right,
Make sure we get it
another
done.
case.
Yes, sir.
Basically said.
I get 5 weeks.
Is that gonna be the last time we're gonna need something?
Yes, sir. That I know of.
Recent.
Thank you, Your Honor. Thank you, Mike.
Algero McQueen.
Ready on that, Judge?
I'm ready. After speaking with Mr. Lear this morning, anticipate this resolving itself. Mr. McQueen is not here this morning. So.
When are they getting here, Tommy?
Sir?
The guys, when are the guys getting here? Like McQueen, for example, Algero.
We can actually get it to him and try to get him here as quick as possible, but.
Well, they're all in, yeah, we got, all. But they're on their way.
Yes.
Okay.
In the event that it doesn't, Judge, I'm going to be at the federal courthouse this afternoon, so if the court could give me some leeway in picking the jury this afternoon.
Okay.
Okay. So we're ready on that one, just unless he pleads.
Okay, what's the odds in Las Vegas on that one disposing?
Can't give you court numbers, Judge. Just after speaking with Mr. Laird.
Well, is probable? Is that what you're hinting at?
Possible.
Possible. Well, it starts with a P.
Well, I suppose if you were reading an injury report, it's playing, doubtful, questionable, out. Somewhere between questionable and.
Okay, that's it. The important thing is we're all certain about it. That's
clear as mud.
Isaiah Brewer.
I filed a motion to dismiss that. That's co-defendant Mr. McQueen. Attorney was here, or she went back as he talked. She's right here, Jim. Oh, there it is.
This says Mark Sparks.
It's Monique.
Oh, it's Monique.
Good morning.
I just knew Mark.
Should type it out.
While you're here, we're gonna sign this thing so you know it's been done.
Make you look real good.
But we could always have a trial if you really,
You know.
the rules of evidence are always enjoyable to.
So YouTube. I'll watch it on my way home on YouTube.
When you're driving?
Like, yes.
Once the evidence comes back out there, maybe you read that, we'll see. I doubt it, but we'll see.
Okay. Okay.
So hold your breath.
I will hold it. You're not playing.
Anything can happen with these witnesses.
The police on the jail.
I've just dismissed Isaiah Brewer, 22-40057. So you're a big fan of that YouTube thing? I've never watched YouTube. I don't watch it. I hear about it, but I've got this thought though, if you're a big fan of that, how about this, one day? We're about to start the trial docket, but first, an important message from Monique Spones. If you need an attorney,
That's not, shop to check it. Thank you, Judge.
haven't sold sponsors, but.
Got the buzzword.
Oh,
Let me know if you need a good pitch for your.
Joe, we're back on,
Xavier.
Xavier Senegal.
Judge, Mr. Senegal's filed a grievance. I've re-urged my motion to withdraw, but other than that, we're ready.
I'm ready, Judge.
Well, so.
I do have a copy of that letter he sent to the court where he admits part of the conduct. So that's not seven.
Been very, very good. Beyond my good.
I deleted it.
Whatever happened in 2013? Well, do you even remember any of that? What he's referring to?
I don't. I think he's mistaken, but I certainly don't remember any. This is the case of his next door. And I think
Just transferred over because Judge West represented him before. Really?
Wow. You should have that one.
He's been evaluated. You want to get him out here?
On the Samsung device, can I get your name?
Oh, been evaluated.
Antoinette Harris.
Harris, Miss Harris. Okay, I didn't want to assume it was you, but I knew you were here earlier. Okay, no problem.
Please, present innocence. That gun? May 30th is what I have.
Yeah, I got it too. Your Quan's report.
10 years in prison if convicted. There is a recent report prepared by Dr. Edgar Khan upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Ed Khan. I am calling these course exhibit number 1 in this court today's date. Any objections?
No.
This would be a part of the record. Sealed and
It's been a while since I looked at it. Does it evaluate only competency?
Take your dance. And May 30th. The Dr. Edgar Pond not only
People against Christopher John Henthorn, 25W713365. Detective, your name?
Detective Kyle Davis.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
On 3/26/24 at approximately 14:26 hours, officers Nicholas Mitchell and Edward Cash with the Woodhaven Police Department performed a traffic stop at northbound I-75 and Vreeland Road inside the city of Woodhaven, Michigan limit. On the defendant, Christopher John Henthorn, officers observed Henthorn was on his cell phone and driving in his hand. Ultimately, Henthorn was arrested on probable cause for being in possession of narcotics that was found inside his vehicle during the traffic stop. The United States Border Patrol K-9 unit and handler Agent Sean O'Donnell performed a free air sniff of the vehicle. The K-9 displayed a positive indication of suspected drugs inside of the vehicle. Officers then searched in the vehicle and found multiple baggies of suspected drugs along with drug paraphernalia. These items were confiscated for evidentiary value and later submitted to the Michigan State Police Laboratory for analysis. Defendant Henthorn was released pending the lab results. The Michigan State Police Laboratory later report revealed 2 of the evidences that were collected as suspected drugs tested positive for narcotics. One of the items tested positive for cocaine in the amount of 5.18 grams, and the other tested positive for methamphetamine in the amount of 23.83 grams. A digital scale with white powder residue was confiscated as evidence from inside the defendant's vehicle, along with $592 in cash in his wallet. That was also collected as evidence for probable cause for possession with intent to distribute.
You have this prior conviction of August 28 of 07 for home invasion second.
Are you asking me, do I have that in front of me at the moment?
You have that. You have his criminal history. Does that show a conviction on that date? Again, it's August 28 of 07, home invasion second, because they're charging habitual second here.
Yes, that is correct.
Now,
I've got a CCH.
go ahead. Go ahead.
August 22nd of 08. Pretty lengthy here.
I'm looking for the home invasion second on August 28, 07, unless that's an incorrect date.
I'm not seeing it on my copy of the of his CCH. I should probably run it again. This was ran.
You have a home invasion second conviction somewhere on there. Yeah, I'm looking at it. It's got August 28, 07, home invasion second. The rest of these, for the most part, appear to be, I don't know what, there's no disposition on a UDAA, but I'm going to authorize, except I want to ask you a question. You said this occurred March 26th of 24. The complaint alleges March 26th of 25. Which was it?
If I said 24, I stand corrected, 25.
Okay, good enough. Based on your sworn testimony, I found the crimes: possession with intent to deliver less than 50 grams of cocaine, possession with intent to deliver methamphetamine were committed. Those are 20-year, and then you have a second offense notice giving rise to the habitual second. I'm going to authorize on both the complaint and the warrant on those charges. You are all set. Thank you very much. Have a good day. We'll put that in lien.
Thank you, Your Honor.
Do we have Brownstone coming in?
She's been contacted. They're waiting to clear the booking.
Concord versus Antoinette Harris. Do I have Mr. Mayers in here, Jennifer? Call her, will you?
I'll bring him.
Good morning, Mr. Mayers. How are you?
Good morning, Judge. Doing well. How about yourself?
Good. And I forgot to return that call the other day. My mistake. I know you said it was nothing to do with court, but I just forgot. I'm going to be honest with you. My apologies.
No problem, Judge. We'll catch up another time.
Okay. What do you have on this Antoinette Harris? Is this a default?
No, Your Honor, we're going to be filing an order of dismissal. I updated these files on Friday afternoon, and we'll send in the order to dismiss today.
Case dismissed, motion of the plaintiff. I also have Concord versus Lashana Warner, 2502237.
We're going to proceed on this, Your Honor. Ralph Mayers, 23815, appearing on behalf of the plaintiff.
I need Jennifer in here. Where's Jennifer?
Thank you for calling Jennifer Wiseman.
Hey, I need you in here. Oh, so she's in there with you? Okay, how long is that going to take? Okay, I'll wait for you, thanks. Ms. Warner is apparently in there on this one. She's listening to the video right now. Are we ready on this, Brownstone?
Yeah.
Bring them in. People against Mitchell. Nicholas James Mitchell, 25B 710 or 714401. Your name, detective?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God?
I do, Your Honor.
Okay, you can proceed.
Your Honor, on June 21st of 2025 at approximately At 5:55 hours, Officer Kenneth Paul was sitting in the turnaround and conducting traffic enforcement on I-75 south of Pennsylvania Road in Brownstown Township. At that time, Officer Paul observed a 1995 Buick Roadmaster Michigan plate 5QSB70, which Secretary of State and Lane indicated was EIV no, indicating no insurance. Officer Paul entered southbound 75 and caught up with the suspect vehicle in the area of southbound I-75 and Dix Toledo Road in Brownstown Township. As Officer Paul closed in, the suspect vehicle increased speed and began to drive away from Officer Paul. Officer Paul activated his patrol vehicle lights and attempted to catch back up to the suspect vehicle, but it continued on at a high rate of speed. Officer Paul caught back up with the suspect vehicle again in the area of southbound I-75 and West Road with emergency lights and sirens activated. The vehicle continued southbound at approximately 120 miles per hour in a 70-mile-per-hour zone, and Officer Paul notified dispatch that he was in pursuit. The suspect vehicle continued to flee from Officer Paul at 120 miles an hour, 70-mile-an-hour zone, and continued to change lanes, going from the far left lane to the far right lane as it was overtaking vehicles. The suspect vehicle continued to flee at approximately 110 miles an hour in a 70-mile-an-hour zone as it passed Breland Road. As the suspect vehicle approached the Gibraltar Road exit ramps, the suspect vehicle positioned itself in the right lane of travel. It braked abruptly, drove through the gorge between southbound I-75 and exit 29B, and exited the freeway at exit 29B for westbound Gibraltar Road. Officer Paul continued to pursue the suspect vehicle as it turned onto westbound Gibraltar Road. The suspect vehicle continued on westbound Gibraltar Road at approximately 70 miles per hour in a posted 45-mile-an-hour zone, swerving from the curb lane into the center turn lane to pass traffic. The suspect vehicle then went northbound on Hall Road from Gibraltar Road, and Officer Paul terminated the pursuit due to traffic conditions at that time. Officer Paul and Officer Nicholas Walker were both familiar with the suspect vehicle due to prior contacts in the Preston Point apartment complex in Brownstown, Michigan. After terminating the pursuit, Officer Paul and Officer Walker set up near the apartment complex to see if the suspect vehicle would arrive. That day at approximately 6:09 p.m., very shortly after the first pursuit ended, the suspect vehicle entered the Preston Point complex, and Officer Walker attempted to stop the suspect vehicle due to its reckless driving within the complex. The Preston Point apartments are a posted 12-mile-an-hour zone, and it is privately owned with private roadways. After the suspect vehicle nearly struck Officer Walker's patrol vehicle, it fled out of the complex and onto southbound Fort Street. At that time, Officer Paul took over as the lead car, and another pursuit began with lights and sirens activated. The suspect vehicle began to smoke and was driving at approximately 45 miles per hour in a posted 55-mile-an-hour zone. The suspect vehicle then slowed down to a near stop, and the driver of the suspect vehicle jumped out of the vehicle and fled on foot across the southbound and northbound lanes of Fort Street. Officer Walker and Officer Paul pursued on foot, and Walker deployed his canine vein to assist in apprehending the driver. The driver surrendered to officers in the parking lot of 28291 Fort Street and was taken into custody without incident. Officers positively identified the driver as Nicholas James Mitchell, both verbally and using his Michigan Secretary of State photograph. At the time of these pursuits, Officer Paul and Officer Walker were both operating black Chevrolet Tahoes with reflective lettering. The word police is the largest wording on these vehicles and is on the driver and passenger sides, as well as the rear liftgate. The vehicles were equipped with blue emergency lighting visible from 360 degrees and an audible siren, all of which were activated during both pursuits. The officers were also dressed in full police Class B uniform with police patches and badges visible to the driver and other motorists. On June 22nd of 2025, Mr. Mitchell was interviewed by Brownstown Detective Attard and admitted that he had fled from police on June 21st of 2025 while traveling southbound on I-75 towards Gibraltar Road, and again when the police attempted to stop him in the Preston Point apartment complex. Mr. Mitchell stated that he fled because he panicked. A lien Secretary of State check for Nicholas panicked.
Okay.
A lien Secretary of State check for Nicholas James Mitchell showed that his driver's license was suspended at the time of this offense, and that he has 3 prior convictions for operating while suspended, revoked, denied, including a conviction for operating while suspended, revoked, denied out of the 33rd District Court on December 11th of 2024.
Based on your sworn testimony, I find the crime of fleeing elude. Third was committed and drive while suspended. Second was committed, probable cause to believe those crimes were committed by the defendant. You can bring them in for arraignment. Mr. Gay, if you're appearing. Clearly comes out of the lockup there. Mr. Mitchell, your name?
Nicholas James Mitchell.
All right.
Good morning, Judge. On behalf of Mr. Mitchell.
All right. How does he wish to proceed for purposes of arraignment?
We'll stand you in waiver.
I'm going to advise you of your rights, Mr. Mitchell. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. At that time, your lawyer will discuss the case and see if they can resolve it with the prosecutor. If it does not resolve at that stage, you have the right to a preliminary exam within 7 days thereafter. If the preliminary exam, at least as to the felony count of flee and elude in the 3rd degree, they have to show that that crime was committed and that you were the one who probably committed that crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court on that charge and any all other charges contained in the complaint and warrant. Do you understand that?
Yes.
Probable cause conference, July 1 at 9:15. You'll be in front of Judge Hessen. July 8th at 11:15 will be your preliminary exam. So 9:15 in the morning, 11:15 in the morning. Again, that's July 1 and July the 8th. All right. Now, what would you like to say regarding bond?
Judge, Mr. Mitchell is asking to request a personal bond on his behalf. He is steadily, Judge. He does have.
Where does he work?
He's working at Wendy's in Brownstown.
Can
He
I
makes
see
roughly
him
about
up here?
$500 every 2 weeks after tax.
He was just in front of me, wasn't he?
I believe so, Judge, yes. He also guaranteed me that he'd be here for court, Judge. He wants court to know that he's not a flagrant record, Judge. I don't believe he's also a danger other than this one particular incident. We asked the court to consider a personal bond or the alternative.
You know that you have a warrant out for your arrest on a drunk driving out of Wyandotte, the 27th? It looks like it was a probation violation. Are you aware of that?
No.
Now you are, okay? What are you asking for there, Detective Toulas?
Your Honor, as you pointed out, this is the second time he's been before you on a driving while license suspended offense in 2 weeks. At this point, we think it would be appropriate to assign a low cash bond on this. During this incident, he did endanger the lives of numerous people and almost struck a patrol vehicle before fleeing from officers on foot. He's shown a blatant disregard for the law in the court. Like I previously said, we'd ask for a low cash bond.
Those two things show me he's a flight risk. What else? Did you want to say something, Mr. Mitchell? It sounded like you were trying to talk.
Yeah, but I was gonna say,
don't talk about the case. Don't talk about the case. You got the right to remain silent. You should not talk about the case.
Oh, no, I wasn't about to talk about the case. I don't have anything in here for me to.
Judge, I believe what he's trying to say is that he doesn't have access to his funds and he doesn't have a way to get in touch with anyone that can bail him out. He requests that he be allowed to either access his phone so he can post his own bond, be able to make a phone call so that he can contact someone.
You guys will give him you don't have, where's your phone at now?
It's in the car. It's in the impound lot.
I see.
I can't do anything. I can't, like, I would cash myself out, but I can't send money to nobody. And then I can call my mom, but she's at work. And then the person that I know could come bail me out. I don't know none of their numbers by heart. That's what I'm trying to say. If you can get me out on a personal bond, I swear to God on everything I love.
I got somebody with a warrant out for their arrest, and I got somebody that I just heard testimony from a detective that they were driving 100 and 20 miles an hour, and they weren't riding on Mars. 15,000, hey, listen, don't interrupt me. 15,000, 10%. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. I wish you well. July 1, you'll be in front of Judge Hessen. You can renew your bond reduction at that time. Good luck to you. And you are going to let him make a couple calls there, Detective, right?
Yes, Your Honor.
Thank you very much. Have a good day, Mr. Mitchell.
Thank you.
Concord versus Lashana Warner, 2502237. Ms. Warner, your name, ma'am?
Lashana Warner.
Got to start your video. Mr. Mayers, your name?
Ralph Mayers, P23815, Your Honor, appearing on behalf of the plaintiff.
Ma'am, did you listen to and understand the rights on the video?
Yes.
You wish to speak to a lawyer?
No.
Do you intend to apply for funding?
I'm sorry.
Do you intend to apply for funding?
Yes.
You do?
Yes.
All right, that entitles her to a 2-week adjournment. I'm going to adjourn this, Mr. Mayers, to July 7th. Ma'am, you have to provide us with proof within 5 days that you've made an application for funding. Do you understand that?
Yes.
All right, so I need that within 5 days. Jennifer, I'm just going to go ahead and set this for 10:15 on July the 7th. Is that good with you, Mr. Mayers?
I'm taking my calendar, Your Honor. July the 7th. That would be wonderful. I already have a matter in front of Your Honor on July 7th at 11:30, so we could do them both that day if. July
I'll make
7th.
it at 11:30 for you then.
That's perfect, Your Honor.
We'll make it at 11:30 a.m. on July the 7th, ma'am. So you have to submit your proof that you've made application for funding within 5 days. Do you have any questions?
I do. Who exactly am I submitted into? How do I go about it?
Okay, so it explained everything on the video. If you come up to the courthouse, they will give you the agencies that you can apply for funding with, and there's a variety of them. So I would come up to the courthouse this afternoon.
So not that portion.
And just wait 1 second, and the staff will give you the names of the agencies that you can apply with, okay?
Okay.
But I'd come up here today.
Okay.
All right, good luck.
Thank you.
Concord versus Stephanie Smith, 2502239.
Ralph Mayers, Your Honor, on behalf of the plaintiff, we'll be sending in a dismissal on this case.
Case dismissed, motion to plaintiff. Concord versus Cynthia Norris, 2502240.
Ralph Mayers, again, Your Honor, we'll be sending an order of dismissal on this case as well.
Case dismissed, motion to plaintiff. And I have Concord versus Matthew Wethington and Caitlin Mills, 2502242.
Ralph Mayers, Your Honor, again, we're sending a dismissal on this case, and that fulfills my obligation this morning.
Nice to see you, Mr. Mayers. Take care of yourself.
Same to
Judge,
you,
if I may,
Judge.
before Mr. Mears leaves, Miss Harris, was she a dismissal?
Yes.
She was. Okay. Miss Harris is coming in right now. I had her showing her the video for her rights. Miss Harris, they did file a dismissal, so you are all set.
Thank you. Okay.
Next
Thanks,
time you gotta
Judge.
be here on time, okay? Good luck. Thank you.
Thank you. Thank you.
All right, Jerry Hicks versus, thanks a lot, Mr. Mayers.
You too,
Bates
Judge.
Chevrolet, 2501754.
Judge, if I may, Miss Barnett and Miss Paulette, you guys are free to leave.
Thank you.
Ms.
Thank you,
Harris?
Bates.
Good morning, Your Honor. Diane Boring, agent for Michael Bates Chevrolet, case number 2501754.
And you said, okay, and your name? I'm sorry, thank you. All right, I have Sherry Graff right here, right?
Yes, sir.
Your name? No, your name.
Sherry Graff.
Your name.
Megan Morris.
All right, and then I have two other gentlemen here that were not here the first time. Your name?
Ronald Lawson.
And your name, sir?
Michael Bowles.
I'm sorry, how do you spell the last name?
BOWENS.
Bowens, okay. What, I don't want, you guys I feel like you're out in center field here. Why don't you come on back up here somewhere closer? There we go. And why don't you, all of you, raise your right hands again. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got. Mr. Hicks?
Yes, sir.
Ms. Boring?
Yes, sir, Your Honor.
Ms. Graff?
Yes, Your Honor.
Ms. Morris?
Yes.
And Mr. Lawson? And Mr. Bowens? Okay, so what did you have to do with this, Mr. Bowens and Mr. Lawson? Who wants to start?
Well, I'm the one, the technician that looked at the vehicle, first. He came in running really rough and not running good at all, hardly even running, and it seemed there was.
Did you have contact with
Did I personally?
Mr. Hicks?
No, sir.
All right, so what did you think about the vehicle?
I wouldn't have spent the money on it. We have a new program that GM came out with that it gives the relative compression of the engine, and that after seeing which direction it was gonna go.
Did you tell somebody that?
Yes, I did.
Who'd you tell?
Well, I give the order, hand it off to the next person.
Who was that in this case?
I guess Megan would be, but it would have had to have gone to get further, I guess, money or time to look at the vehicle.
Slow down.
Because of the direction we were going.
Slow down. You told her that you wouldn't spend the money on it. True or false?
True. True.
Did you ever convey that, Ms. Morris, to Mr. Hicks?
No,
Why not?
because that's not I can't tell someone whether or not they should get their vehicle fixed. I can only present them with what was wrong with the vehicle.
So I want to just make sure I understand this. I don't want to put words in anybody's mouth. If a mechanic tells you or tells anybody at Bates that they wouldn't spend the money to have the vehicle repaired, given the nature or issues with the vehicle, Bates Chevrolet takes the position that that's not their decision to make. It's not their position to tell somebody that you shouldn't get the vehicle repaired based on the mechanic's opinion. I just want to know if that's true.
I just told them that it had to be further diagnosed and had to go to a different technician.
All right. Lisa, Jennifer, did you guys file a counterclaim like I told you?
Yes, we did, sir.
Jennifer, do I have a counterclaim?
Judge, it should have been attached to your packet. Probably like the last piece of paper.
What'd you have to do with this?
Me?
Yeah.
I put the engine in the vehicle, sir. I'm the heavy tech,
Uh-huh.
and Megan brought the RO to me. I need a price on the engine.
Did you ever talk to Mr. Lawson about this?
Mr. Lawson?
Yeah.
Yeah.
And did he reiterate to you that he wouldn't spend the money on it?
We both agreed that it wasn't a good vehicle to put that much money in.
Did you tell that to Mr. Hicks?
I never talked to Mr. Hicks, sir.
Did anybody here that works for Bates tell Mr. Hicks that they wouldn't put the money into the vehicle?
Can I speak, Your Honor?
Wait a minute. I'm asking, did anybody here ever speak to Mr. Hicks and tell him that the mechanics think it was a mistake to put any money into the vehicle? Did you tell him that?
No.
Okay, so I haven't heard from anybody. So nobody told Mr. Hicks that. I just want to be clear.
Not that I'm aware of.
And do you agree with that, Ms. Boring?
I was not present, sir. I can't
I
comment.
know, but you know what? Now this is bad. This is bad.
Your Honor, may I speak?
I don't care who speaks. You guys are in deep trouble right now.
Well, Your Honor, a lot of people are fixing older vehicles with the way the economy is, and they are investing a lot of money in older vehicles.
That's
right now.
fine.
It's not.
He could have decided he was going to put $200,000 into the case because it was sentimental. I don't know what happened. Maybe he kissed a girl in there the first time. I don't know what happened, but all I can tell you is this. Bates owes an obligation, as does any other company, to advise people when they shouldn't go forward with trying to repair something that's not repairable. So here's how I see it right now. He gave you $4,000. You want how much more from him?
The dollar amount.
$4,400, sir.
They want another, you want another $4,400, and you're still telling me the vehicle isn't drivable.
They still have my vehicle, Your Honor. It was not in the parking lot, as I said it was. I went the day before. You asked them if you went that day.
I mean, I think, does anybody dispute here? This kind of really gets me here. Does anybody dispute that a company, in this case, a dealership, owes an obligation when their mechanics look at the vehicle and they think it's not repairable to at least notify the customer of that? Anybody think that's not what should be done over here? If it is, I want you to tell me. Do you think that's not what should be done?
So, Your Honor, he didn't say it wasn't repairable. He said he wouldn't put money into it.
Come on,
And that's his personal.
come on. He's the mechanic.
I know that.
Well, he's the guy who should know. If he doesn't know, who does know? I mean, come on. This is what people get hired for. Doctors wouldn't tell us to go through with the surgery if they thought it was going to be worse. Lawyers wouldn't tell us to take certain action if they thought it was going to be worse. Dentists wouldn't tell you to get a root canal if you didn't need one. This is bad. No. Anything else?
Your Honor, no, sir, you're handling it just fine.
You're a smart man. My father told me when I graduated law school, he said, if you're winning, you might want to just keep your mouth closed until the judge makes his decision. Do you guys have anything else over here?
I don't.
Ms. Morris? Mr. Bowens?
No, sir.
Mr. Lawson?
No, sir.
I don't want to sit here and lecture people. You guys are too old for me to do that, and I can say that because I'm fairly much older than all of you. This is,
disagree.
hang on,
I disagree with you, Your Honor. I think I'm older than you.
this is not,
I'm 78.
this is not right. You go back and tell Bates or whoever's running that I said it's not right. I'm ordering this vehicle be returned to him, and I'm ordering that you pay judgment to him in the amount of $4,000 plus its cost of $82. And I'm also going to order that there be no cause of action on the counterclaim. You can't lure people in. That's the way I feel this was done. If a mechanic looks at something and says, I wouldn't put the money into this, you have an obligation to tell the person. You don't just let them make a decision at, well, this might fix it, this might not, and then do $4,000 more worth of work. Well, we still don't think we have it right. He's got a $3,000 vehicle that he's now into, at least people want him to be into, for $11,000, plus it's still not working. I want you to get him a check today. Can you get a check today? Can you return the vehicle to him today? Any reason you can't? Thank you. Judgment for plaintiff. No cause of in the counterclaim. Thank you. I know it's hard to remember.
Oh, yeah, she's there, sorry.
That's okay. It isn't really.
I have your favorite judge.
Oh, yeah.
At least not.
Jalen Kashawn Jackson, 25B1486338A. B and C, we're gonna issue a show cause on the A file, default judgment on the B and C file. Harper, Aaron James Harper, 25B148510. Defrauding an innkeeper, issue show cause, defendant failed to appear for arraignment and pretrial. People against Angelica Marie Sucaro, 25B1475543A, B, C, and 21W828729. All right, on 7543A, defendant failed to appear. This was for a show cause after not appearing previously at least twice. $5,000, 10% will be the new bond. On the B file, $1,000, 10% on that file. And on the C file, $1,000, 10%. And also on 21W828729, 3,000, 10%. Jeez. Make sure I get 10% on one of those, will you? Just double check all these, please.
Will do.
Shannon Lane Argue, 25B1486128A, B, and C. On the A file, 1,010% for failure to appear for show cause on the B file. 3,010% for failure to appear for show cause and on the C file. Defendant should have been and was defaulted back on May the 21st. People against Boland, James Thomas Boland, 25B148509A, B, and C. And also 25B14863.
Is in custody, you need to request them by the deputies. Once you've requested them, do not leave the courtroom because is there someone at the back door? For security reasons. Okay. For security reasons, they can only have so many inmates in at a time. If your client wishes to speak to the court in a language other than English, we'll need an interpreter, whether you speak that language or not. Once we're on the record, you'll know we're on the record because I will have called the style of the case. Please do not talk behind the court reporter. It makes it difficult for her to hear. Just raise your hand. The deputy will move you to the other end. Does everyone understand the instructions? The other thing, probation is here. They're an integral part of this process. So if you have someone who's on probation, if you have someone who you think you're going to have placed on probation, you need to confer with the probation officer. All right, it's Monday. It's a beautiful day. It's going to be hot. They tell me we're going to have a lot of wind at noon. So it's going to be blowing hot air. But we're going to enjoy the day because we're currently alive. So everyone, please confer.
Mr. Romero? Yes. Please come up here. Number?
692-009.
Hey.
Christopher Meyer.
Sure.
Christopher Meyer.
Really catch, Your Honor. And he was
David Lopez.
being assessed.
Verify something.
Who's Jenna Brewer?
My daughter.
Is she in the home too?
No, she lives somewhere else, but she's not doing it. She's at work.
Where's Mr. Reese?
Right here.
I need
Are you
to see
here, ma'am?
Mr. Reese. Mr. Reese, please don't tell me you're at 7167 Campbell in the city of Taylor.
No, Your Honor.
No, you're not. Okay.
At my grandparents.
Mr. Reese, you need to meet with an attorney, but if you are at that location, you are in violation of your bond conditions.
I'm at my grandparents, Your Honor.
Mr. Gazicki,
Yes, Your Honor.
Mr. Reese is here. The complaining witness on this case is individual named Jenna Brewer. Mr. Reese is showing up with Miss Brewer's mother. They're sharing a device. And I don't know where they're at, but I have pretty significant concerns that they're at 7167 Campbell, which is where Mr. Reese has a no contact order. He's not to return to that address or have any contact with complaining witness. So Mr. Reese,
I don't have a file on Mr. Reese.
We'll get you the file, Mr. Reese. I'm going to put you in a room with your lawyer because you need him.
Yes, Your Honor.
And then Mr. Reese can get put in a room, and then we'll do this waiver, and then I'll handle Eric Martin and Winslow real quick, and then we'll move to Harris while he's kind of talking to Mr. Reese. All right, we're on record. This is 251493, the people of the state of Michigan versus Brandon Kyle Edwards Williams. Appearances.
Good morning, Your Honor. Donna Sol on behalf of the people, PA 7439.
Good morning, Your Honor. Nancy Castle, NDS, appearing on behalf of Mr. Brandon Williams, P number 805.
All right, so it's a time and date set for preliminary examination. How are we proceeding?
Your Honor, I just, the people are ready to proceed. We had her witnesses present, sister counsel informed me they'll be.
That's right, Your Honor. I did have an opportunity to speak with Mr. Williams, explaining his rights to this hearing. At this time, Mr. Williams is waiving his appeal.
All right, Mr. Williams, you understand everything we're talking about here today?
Yes, ma'am.
Can I board hear your client just briefly, counsel?
Absolutely, yes.
Mr. Williams, you understand under Michigan law, you have a right to a preliminary exam. You understand at that exam, the prosecutor would have to show probable cause that a crime was committed and that you committed that crime. You understand that?
Yes, ma'am.
And you understand if you waive that exam, you'll be bound over to Third Circuit Court for all future proceedings. And it'll be on the charges in the complaint and warrant. You understand that?
Yes, ma'am.
And did you have a chance to discuss the charges against you with your attorney?
Yes, ma'am.
And the habitual offender fourth offense notice?
Yes, ma'am.
All right, I'm satisfied. The case will be bound over to Third Circuit Court on the charges in the complaint and warrant. For all future proceedings, your arraignment on the information day is Monday, June 30th, 2025 at the Criminal Justice Complex. Okay, Mr. Gazicki, and we're all set. Thank you. Mr. Gazicki, are we ready on Mr. Winslow? Mr. Winslow, can you turn your camera on? Mr. Winslow, if you turn your camera on, I'll call your case, sir. Okay, Mr. Winslow, you have to figure out how to unmute and how to turn your camera on. This is 251756. Oh, there he is. Okay, Mr. Winslow, this is 251474 FD, the state of Michigan versus James Douglas Winslow.
Good morning, Your Honor. James Gazicki on behalf of Mr. Winslow. Waive reading of the complaint, stand mute, request court-appointed attorney, also ex parte order to preserve.
All right, Mr. Winslow, can you tell me your first and last name?
James Winslow.
All right, Mr. Winslow, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you, as Mr. Gazicki was appointed to represent you today. And I have signed an order so that you have attorney at your next hearing. I've also signed the ex parte order preserving evidence to ensure your counsel can get discovery on your case. As to bond, Mr. Gazicki, Oh, wait a second. You have 2 days within the next 21 days, Mr. Wenzel. Your first date is your probable cause conference, and that is set for June 30th, 2025. You can appear at that hearing via Zoom. Following that will be your preliminary examination, and that will occur on July 7th, 2025 in person at the 23rd District Court, and you'll receive notice of both of those dates in the mail. As to bond, Mr. Gazicki,
Your Honor, I'd ask for a personal bond. Mr. Winslow appeared today. Does not appear to be a flight risk.
all right, Mr. Winslow, you did appear today. I'm giving you a personal bond, so you don't have to post any money, okay?
Thank you.
These are the conditions of your bond, sir. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You cannot consume alcohol or illegal drugs. You will be subject to random drug and alcohol testing while this case is pending. You cannot operate a motor vehicle without a valid license. Do you understand all of that, sir?
Yes, I do, but I am on some prescribed medication from surgery.
Okay, well, is it alcohol?
No.
If you're on if you're taking prescribed medications, you'll just need to provide proof of those prescriptions to the probation department. And they're going to contact you to set up your testing, okay? Because you will be tested while you're on bond.
That's fine.
Okay, they'll reach out to you, sir. Make sure you answer if you get a weird number so you know that you, so that okay, so that you are in compliance. All right, you're all set. All right, on 2-5, thank you, sir. Have a good day. On 251.
Those will be mailed to me?
Yes, sir. Mr. Winslow, they're going to call you as well.
Okay.
So you'll receive notice of your next 2 court dates on the 30th, but you know you need to be here next Monday morning, and you need to be here the morning of the 7th. Those are your next 2 hearings, but you'll receive notice from the probation department about testing. Understood?
Understood. Thank you, Your Honor.
All right, you're all set, sir. Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her. Did you swing at me before I kicked you? She answered no to that. And it was seen on the camera. She lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial by
so I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm gonna object to you being the judge based on past constitutional violations. I'm gonna need to
Okay, well, your
disqualify you,
motion for recusal is denied. So
Okay.
now, Mr. Martin, are you electing for me to try the case, yes or no?
In that force the sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said, Article 3 judge. Article 3
Okay.
judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find me
Despite the fraudulent presumption otherwise.
possible? All right, give us a second, Mr. Martin. I'm trying to get your jury trial date.
We can even do on a state day.
I want to make clear, I'll point out, it's supposed to be 28 days and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just gonna say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, it's a misdemeanor, so we're not having a preliminary exam. We're having a bench trial, and the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this. If you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin.
As of right now.
What's your last motion? Do you have one more?
You haven't let me finish let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against me. Somebody have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be. Come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay. Thank you, Mr. Gazicki. That's it, right? Okay.
I have 2 iPhones with their IP.
I'm gonna go ahead and handle this hearing and they can, okay. I have 2 iPhones in the courtroom. I need to know your names, please. I have iPhone. Can you unmute and tell me your names? All right. And Mr. Gazicki is meeting with he should be meeting with Mr. Reese at this time.
Yeah,
Mr.
I'm Donna
Reese?
Brewer.
Yeah, Ms. Brewer, I've got you. Do we
Okay.
have Mr. Reese here? On the other iPhone, it's muted. I don't know. I mean, we already saw you together. I don't know what good this does, but Mr. Gazicki, I believe this other iPhone is Mr. Reese.
Tyler, you gotta,
No, she's a complainant's mother. Now we lost that other iPhone. All right, come on up. Let's do this hearing.
Is this for Carlos Harris?
Carlos Harris.
I have an officer here.
All right. The officers may or may not be called for testimony.
My phone was messed up, Grandma.
All right, Mr. Reese, we're going to put you in a room so you can speak with Mr. Gazicki. He has your file.
Oh.
So join that
Oh,
breakout.
yes, Your Honor.
And can you put this in, give this to Mr. Gazicki? It's the criminal history. All right, that's on Reese, yeah. All right, this is 242945, the People versus Carlos Harris. Appearances.
Good afternoon, Your Honor. Nathan Gasner requesting permission under MCR 8.120 to conduct this hearing. I am a recent graduate at the University of Detroit Mercy School of Law, and I am under the supervision of APA Donaso.
Okay, can you do me a favor, Madam Prosecutor, or soon to be Madam Prosecutor? Can you spell your first and last name for the court order?
First name is Natala.
This would help.
Niela. Last name Asmaro.
Okay, thank you.
Good morning, Your Honor. Alexandria Taylor appearing on behalf of the defendant, Carlos Harris, P 75271. Mr. Harris, please state your name for the record.
Carlos with a K, last name Harris.
Okay, and permission granted. Okay, so before we get into the, you can be seated, everyone. So before we get into whether or not we need testimony on this, I just have a few questions. I've reviewed all of the case law on this. I've read Pomeroy, I've read Wood. I've read, what's the third case on this now?
So we had Stephen, is that the one you're talking about? There's Pomeroy, Wood, Stephen, Chanela.
Fulcher.
Which one?
Pomeroy, it was the Pomeroy Fulcher court. And then this case, the Wood case discusses Pomeroy in detail.
Right.
I need a few facts that I need to know if the parties are willing to advise. At the time that the stop occurred, and stops in quotation marks because the vehicle was alleged to have been stopped, was the vehicle in park?
Yes. The vehicle was parked but running.
Okay, but it was parked.
Yes.
It was in park.
Yes.
Okay. And the defendant was behind the wheel sleeping.
I don't believe the defendant was sleeping, but he was behind the wheel, yes.
He wasn't asleep.
Okay. I just saw that in the
That's
motion.
reflected in my hand.
So for the prosecutor, when I read this Wood decision, okay, so they're basically parsing these cases into two types of cases. And they make this distinction between these cases that they've previously heard based on the evidence that came forward in Wood. So in Wood, we had an individual that was in his van at a drive-through window, and law enforcement stopped him and wrote him up for drunk driving. His foot was on the brake, but the vehicle was in drive. Okay, and they discussed that case, and then they come to a decision when they're reviewing Pomeroy, the Wood case, that there's this distinction specifically in the Wood case because the vehicle was in a position to cause significant risk of causing a collision. Such a person continues to operate it until it's returned to a safe position. So they basically say in the Wood decision, the fact that the defendant's the car was in drive and the foot was on the brake, if his foot slipped off, the car would be moving again. But in this case, we have a car that's parked, and I'm not certain how under Pomeroy and Wood, what the legal basis would be for the charge. I'm asking.
Your Honor, the people are relying on People versus Chanela, which allows for circumstantial evidence.
What's the citation?
People, the.
It's 160 Mish Ave 213.
Yes. Thank you.
Okay, go ahead, I'm listening.
Yes, so it allows for circumstantial evidence to come in to show that the defendant was operating a vehicle under the influence prior to arrest. And that's what we're relying on, as well as the definition of operation, which is under MCL 257.6251, which doesn't require the officers to witness the vehicle in motion. And that's what this case is, circumstantial evidence to show that the defendant was operating the vehicle while under the influence prior to the arrest.
Yeah, respond. Your Honor, you ready?
Yeah.
You said yes.
Uh-huh.
So the circumstantial evidence has to be actual evidence. So just like in People v. Stephen, which is 262 Mish Ave 213, a 2004 case, in that case, the court found sufficient evidence to support an OWI charge. And so there, the defendant admitted to driving to the fairground to sleep off the effects of having too much to drink. He struck the parking log while attempting to leave the fairgrounds and turned off the engine and went to sleep after he was unable to dislodge his truck. So yes, it can be circumstantial, but that's the circumstantial. There has to be something. The cite for that one?
No, read what you just said to me.
So the court found sufficient evidence to support an OWI charge where defendant admitted he drove to the fairground to sleep off the effects of having too much to drink, struck the parking log while attempting to leave the fairgrounds, and turned off the engine and went to sleep after he was unable to dislodge his truck. And that's at 219 and 220, the Penn site. So the circumstantial evidence, obviously, in Stephen was defendant admitted he had too much to drink and he physically hit something with his vehicle. And even though his engine was turned off, he was unable to dislodge his truck. He was stuck after hitting something. And so we don't have those type of facts here. And so yes, it can be circumstantial, but again, we don't have anything like Stephen and Chanella here. And we have the body cam. There's nothing here. There will nothing. If these officers testify pursuant to what is on the body cam footage, there won't be anything. And in fact, on the body cam at roughly, I think it's around 22, I think it was Officer Shields specifically remarked, and he said, well, his speech isn't slurred, you know, like there was nothing. And so we don't have the circumstantial evidence that is found in these other cases, or even like the case Your Honor cited, People v. Wood. In that case, the defendant also had a beer between his legs. So it wasn't just that his foot was on the brake, he had a beer in between his legs.
What is
also in the
this?
drive-through.
I'm sorry, I don't want to cut you off, but what, 262 MA, what was the rest of that, Mish Ave, what?
213.
Your Honor, may I respond to that as well?
You may.
I'd argue that we do have similar facts as to that. Unlike the case you just cited, the vehicle was running opposed to turned off, but also there were, after speaking to Officer Shields, he did mention to me that there were statements made before, as well as an interview conducted where he did state to drinking prior to and to also having driven and then stopped to take a nap or take a break. So I'd say that the facts are similar to that case.
Do you know if statements were made?
So the officer said, have you had anything to drink? And my client indicated that he had a drink several hours prior, and there were follow-up questions to that. And so, yes, and then he stated he had been at the hospital. I believe it was Mott's Hospital. His daughter was hospitalized. And so he said he had been at the hospital, and he was like, he was tired because he had been at the hospital. And so there was a statement, but different than in Stephen, the site that I just gave you, where that defendant admitted he had too much to drink. So saying I had a drink several hours prior, that is not the same as in that case that I cited.
Your Honor, Mayor.
Go ahead.
Thank you. We also want to add that there was a interview conducted where the defendant was Mirandized, where he again stated that he did drive this vehicle. He stated that he was taking a nap or taking a break or whatnot, and placed the vehicle at what they call, officer called it a gore, which is the middle of the, from a merger to the highway, which is, again, that's not a safe place to also put a vehicle. But he was the only individual in the vehicle, and the statements that were made before being Mirandized as well as being Mirandized were that he did drive the vehicle, and that's what we believe to be enough circumstantial evidence, at least at a probable cause standard, for this to be a question of fact or the trier of fact.
All right. Let's hear some testimony. Okay. Who do you want brought in first?
Officer Shields, he's on Zoom.
Okay. I'm trying. Hello, Officer Shields, can you hear me okay?
Yes.
Sir, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name and employment for the record, please?
Mayan Shields, Michigan State Police.
Okay. Officer Shields, I know how your first name is spelled, but can you spell it for my court recorder?
Yes. CEMIYEN.
Okay, great. Madam Prosecutor, your witness.
Thank you, Your Honor. Good afternoon, Officer Shields. Could you please, well, you already stated your name on the record.
Amy.
Could you hear me or can you hear me?
Yes. Yes, ma'am.
Thank you. Okay, I want to take you back to the date of February 19th, 2023. Did your duties as a police officer take you at or near the location, East I-94 freeway near Telegraph Road?
Yes.
Is that in the city of Taylor, County of Wayne?
Yes.
And what were you in that area for?
And just on general patrol.
Okay, were you with anyone or were you by yourself?
I was with the partner.
Who was your partner?
Trooper Elia.
Okay, and were you in a vehicle at this time or on foot patrol?
We're in a vehicle, fully marked patrol, Michigan State Police vehicle.
And were you in uniform that day?
Yes, we were.
Was it full or partially marked, or was it full or modified uniform?
Full uniform of the day.
Okay, and were you, when you were in that area, what, if anything, did you observe?
I observed a black Cadillac SUV parked in the gore on the freeway.
And what is a gore?
The gore is the section between the entrance or exit ramps of the freeway that comes to a tapered V.
Okay, and do you remember if that vehicle was running or not at that time?
Yes, the vehicle was running.
Okay, and what did you do when you saw this?
I pulled behind the vehicle to check on the vehicle. We ran the license plate. I exited the vehicle, approached the vehicle, and observed a black male behind the driver's seat. He rolled down the window, and we began to interact.
And how many individuals did you see in that vehicle?
Just one.
Okay, and Your Honor, would you like identification or no?
I don't know how he's going to do that through Zoom for identification.
Okay, it's not an exam. Okay, so you made contact with the driver of that vehicle?
Yes, ma'am.
Okay, and did you observe anything when you made contact?
No, just that he was appeared to be waking up.
Okay, and what happened when you made contact with him?
I began to ask him several questions of where he was coming from, what was he doing, which led me to ask him if he had been drinking that evening.
And did he respond to any of the questions you were asking him?
Yes, he did. He told me he was he pulled over because he was tired. He was coming from I believe Ypsilanti.
Okay, and you stated that you also asked him, you were led to ask him a question about whether he had drank that night or that day.
Yes, I asked him if he had anything to drink, and he told me he had something around 8 p.m.
Okay, and why did you ask him that?
Just common questions for when we stop individuals. You may suspect something with their driving behavior that would lead you to believe that they may be impaired. The position of his car on the gore led me to believe that he may have been intoxicated, because normally when people pull over, they usually park on the shoulder, not in the gore, unless their vehicle is disabled or anything like that.
Okay, and what happened after he did tell you that he had a few drinks?
I would object to it. That wasn't the testimony.
He said he had a drink,
Yeah.
right?
A drink, I apologize. What happened after he made that statement to you?
Which statement?
The statements regarding the drinking.
Oh, I asked him to step out of the vehicle and he complied.
Okay, and why were you asking him to step out of the vehicle?
Because I wanted to further investigate to make sure he wasn't impaired.
Okay, and at any time, did you make any other observations as to whether he might be impaired?
Yes. When he exited the vehicle, as I was escorting him back to my patrol car, I could smell the odors of intoxicant.
Okay, and then what happened after?
I ran him through a field sobriety test.
Okay, which field sobriety test did you recall?
Horizontal gaze and nystagmus was the first one. The walk and turn was not conducted due to the position of us on the freeway. It wasn't safe to do so, and the one leg stand.
Okay, and what happened during, let's start with the first test, the horizontal nystagmus, I believe you stated.
Horizontal gaze and nystagmus.
Yes.
Mr. Hare's pupils displayed equal tracking. There was no sign of resting nystagmus. There were no indicators of lack of smooth pursuit or any clues of impairment with the horizontal gaze nystagmus.
Okay, and then you conducted a second test. Was this the one leg stand test?
One leg stand test. That test was administered. There were no clues also with the one leg stand test.
And what did you do after these tests were conducted?
Well, we had already called for PBT because he had requested that he would just take a breath test. We had already requested one, and one was en route. So as soon as that arrived on scene, we administered that, and that's when it was indicated that his BAC was a 0.12.
Okay, and after seeing the results of that test, what happened after?
Placed Mr. Harris under arrest.
And what was he placed under arrest for?
OWI.
Okay, and then was he later transported?
Yes. He was advised of I have to look at my report to make sure I get the order corrected, if you don't mind.
If it would refresh your recollection, do you have your report with you?
Yes, I do.
Okay, if you'd like to take a look at your report, you could.
Oh.
And then whenever you're ready, please just let me know. I can ask again.
Okay. Okay, after he was placed under arrest and secured in the vehicle, he was read his chemical test rights, in which he agreed to a chemical breath test. He was also read his Miranda rights, in which he stated he understood his rights and agreed to answer my questions.
Did you read the defendant his Miranda rights?
Yes.
Okay, and did he understand those rights?
Yes, he said he understood his rights and agreed to answer my questions.
Okay, and how did you read? Did you read them out loud or was it on paper?
Verbatim from a department issue card that we have. It's a UD52 card.
Okay, And where did this take place?
This took place in a patrol vehicle.
Okay. And at that time, did he appear to be under the influence of anything to you?
No, his speech and everything was not slurred, other than odors of intoxicants and him admitting to consume some alcohol. There was nothing else.
Okay. And did the defendant provide a statement?
Yes, he did.
And what did he say?
Would you like for me to read it verbatim?
Do you have, if you could, sure, yes.
Okay. When I interviewed Ms. Harris, the first question I asked him was, when was the last time you had something to drink? Answer was, I probably had something to drink around maybe 12:30 a.m., 12 o'clock a.m. I went to the charity room around 8 o'clock. Next question, where's that located? Answer, Ypsilanti on E-Course. American Legion. It's a lodge for veterans. Question, how many alcoholic beverages did you have while you were there? Answer, I probably had 2, and one of them I didn't finish. Question, what kind of alcoholic beverages were they? Answer, vodka, a double shot of apple Ciroc. Question, so 2 double shots of apple Ciroc, and that was the only thing you had? Answer, yeah. Question, what freeway do you think you're on? Answer, 94. Question, 94 where? Answer, 94 just. What do you mean 94 where? Question, where at on 94? Answer, I would assume it was probably Allen Park 94. Question, how about a cross street in which direction? Answer, I don't know all that. I don't live in Allen Park. Question, were you going east, west? Answer, I was headed east because I live down. Like I said, I live in Grosse Pointe Shores. I was headed home, but as I stated before, I thought I possibly should went to EMU to Michigan Mox, but I was like, fuck it. I just head home. Pardon me. I just head home, but I've been calling my wife, calling everybody. Nobody answered. So I said, fuck it. Man, I just pulled over and took me a nap. Question, on the scale of 1 to 10 on the effect of alcohol has on you, where would you rate yourself? Answer, 2. And that concluded the interview.
Okay, and was that the end of your involvement in this case?
Next, he was transported to the Michigan State Police Detroit Detachment, where the data master was administered for the chemical breath test.
Okay. And I have nothing further. Thank you, Officer Shields.
Cross.
Yeah. Officer Shields, is it fair to say that you don't know how long Mr. Harris was there?
That is correct.
And when you first encountered Mr. Harris, the vehicle was completely stationary, correct?
Yes, ma'am.
And so it will be fair to say you never personally observed that vehicle moving, correct?
That is correct.
Would it also be fair to say you did not observe any tire tracks, skid marks, or any other signs indicating recent movement, correct?
That is also correct, ma'am.
And you said that you instructed Mr. Harris to exit the vehicle and he complied with your instruction, right?
Yes, ma'am.
He didn't stumble out of the vehicle, he got out of the vehicle as normal, correct?
Yes, ma'am.
And it's also your testimony that out of the field sobriety test that you did perform, there was no indication of impairment, correct?
That is correct.
Now, I want to clarify something because you said that you had called for a PBT because it was requested. Is it your testimony that Mr. Harris requested it?
We had already requested a PBT, but he was asking his I believe he said I'll blow in the machine or just breath test me or something like that of that effect. I can't recall exactly what he had said. I would have to review the body camera footage.
Okay, and so I'm just gonna ask you if this would refresh your recollection from the body cam when you were doing the one leg stand and demonstrating that Mr. Harris had indicated that he had gout, correct?
Oh, yes, yes, ma'am.
And at one point in time, there was a discourse about whether he was agreeing to do the test, and there was a mention of a PBT. However, Mr. Harris did the test successfully, correct?
Yes.
How long did you have to wait for a PBT to arrive?
I would say approximately 7 to 8 minutes. I would have to review the body camera footage to see from the time that we requested it till it arrived.
And also, it's fair to say there were no calls into law enforcement about a vehicle in the road, correct?
No, ma'am.
No reports of any accident or crash involving Mr. Harris?
No, ma'am.
His vehicle did not have any signs of indicating that it was an accident, right?
No, ma'am.
And in fact, isn't it fair to say that at one point on the body cam, you made a comment saying, well, he's not slurring his words, almost saying that there were no indications that you saw of intoxication, right?
That is correct.
And so outside of Mr. Harris being completely honest, saying, okay, I had a drink and didn't finish the second one, there was really nothing else, correct?
Correct.
All right, nothing further.
Any redirect?
No redirect.
Can this witness be excused?
Yes.
All right, thank you, Officer Shields. You're all set.
Okay, thank you, Your Honor. Have a good day.
Yeah, you too. Is there another witness?
No, Your Honor.
Okay.
Your Honor, we would move to admit the body cam just for the record purposes.
Okay. Any objection?
No objection, Your Honor.
Are you going to provide me a copy of that?
Yes.
Okay. Because we don't have to watch that now.
No.
I can review it and then come to my decision.
Are we making final arguments or no?
I'd love to hear final arguments. Okay. Wait, you're first.
Yeah,
It's
I'm
your
first.
motion.
Yes. It's easier for me to be right here. On my papers. Your Honor, the prosecution has failed to establish probable cause that Mr. Harris operated a motor vehicle while intoxicated as required under the statute. As a matter of law and under the facts of this case, bind over is improper. As we just discussed earlier, the premier case on this issue, People v. Pomeroy, 419 Mich 441, a 1984 case, where the Supreme Court held that a defendant could not be convicted of a drunk driving offense where he was sleeping in a motionless vehicle. As Your Honor articulated.
Ms. Taylor,
yeah.
I don't want to interrupt, but this is a misdemeanor.
Yes.
Okay, because you said bind over.
Oh, I'm sorry. Yes.
Okay.
And so, as Your Honor has stated, since People v. Pomeroy, the court has refined that holding, and in People v. Wood, the defendant was found asleep behind the wheel with the beer between his legs at a fast food drive-through. The court found that there was sufficient evidence to believe that the driver operated the vehicle while intoxicated at some point. The case I cited previously, People v. Stephen, again, the court found there was sufficient evidence where the defendant admitted that he drove to the fairground to sleep off the effects of having too much to drink, struck something, and then his vehicle was dislodged. The same on People v. Shinella, that is a case where the defendant was in a ditch. Here, Your Honor, in this case, Mr. Harris was found inside a stationary parked vehicle. Officer Shields testified he did not know how long Mr. Harris was there, never saw the vehicle in motion, didn't see any skid marks, tire tracks, anything to indicate that the vehicle slid or was in an accident. There was no proof of movement, no time frame as to how long the vehicle had been parked and no statements from Mr. Harris regarding recent driving. And even in the statement that Officer Shields read, the question and answers, Mr. Harris said, I went to take a nap. And so even if we look at the timeline of things, when this happened, there is no evidence, especially considering Officer Shields' testimony here today of not knowing how long Mr. Harris was there. There's no evidence. And so, yes, Madam Prosecutor is right. It can be circumstantial, but here we have no circumstantial evidence. And even with Officer Shields, he testified that there, for the horizontal gaze nystagmus, there was no sign, no indication. The one leg stand, no clues of impairment. Mr. Harris got out of the vehicle without issue. And as I stated in, if Your Honor was to listen to the body cam, Officer Shields remarks at a point and it says, like, bring his words almost like there's nothing here. And I contend that the testimony surrounding the PBT, Mr. Harris did not request it during the course of the one leg stand. When the officer said, do you have any injuries that would prevent you from doing this? Mr. Harris said, well, I have gout. And so there was a discourse back and forth where it said, okay, if you refuse it, you have to do the PBT. But ultimately, Mr. Harris did not refuse. He did the one leg stand and even with gout, performed that test successfully, Judge. And so short of the officer saying, okay, we're getting this PBT, there was nothing, no probable cause, no signs of intoxication, impairment, nothing at that point. And so there was nothing on the record, especially here today after Officer Shields testifying, showing that there was a reasonable inference of intoxication. And so it is our contention that they failed to meet the probable cause standard for bind over. And even, I know Officer Shields says today it was 7-8 minutes, the video will reflect the actual time, but even under Rodriguez versus United States, the officer can only keep you there within a reasonable time. And once it passes that, absent independent reasonable suspicion, you have to let someone go. So at that point, before the PBT even gets there, Your Honor, Officer Shields says there's no indication of impairment. And so Rodriguez says that a traffic stop becomes unlawful if it is prolonged beyond the time reasonably required to handle the initial justification for the stop. Well, Officer Shields testified that he asked Mr. Harris to get out of the vehicle because, again, when he went up to the vehicle, he did not say that he smelled any odor of intoxicants. He didn't say that until after Mr. Harris got out of the vehicle, and he wanted to do the field sobriety test. The whole purpose of the field sobriety is to ensure that this person is not impaired or intoxicated. And so you do the field sobriety test, and then Officer Shields says he performs it, even clarifies he wasn't slurring his words. And so at that point, then to keep Mr. Harris beyond that, you run afoul of Rodriguez where it says, look, the initial justification for the stop, which really the initial justification was more so impeding traffic, which is a civil infraction because he's in this gorge. And then you walk up to the car, Mr. Harris says what he says, and then they ask him to get out. We want to check and make sure. You check and make sure, and there's nothing there. The officers confirmed no signs of impairment. No probable cause existed at this point, yet the officers unlawfully prolonged the stop, culminating in Mr. Harris's arrest. Your Honor, there's nothing here that would give rise to probable cause that Mr. Harris was operating while intoxicated or impaired. And so, Your Honor, we're asking that the court grant our motion in this matter and dismiss.
Thank you.
Thank you.
Response?
Thank you, Your Honor. The people are requesting that the motion, that defense's motion to suppress be denied. We believe that there is sufficient evidence to keep this case going. In response to defense counsel stating that there was no testimony stating how long the vehicle was there for, the officer didn't know how long the vehicle was there for. We believe that that's not something we need to really know. It's just we have to show that there was operation of the vehicle, not how long that it was there for. And we believe that that's been showed here. There were statements that were made before and after being Mirandized, indicating that the defendant was operating the vehicle, and there were also the vehicle being in the middle of an area that is, again, dangerous to have stopped there. There were, as Officer Shields testified earlier, that there was an odor of intoxicants when the individual was being asked to exit the vehicle. And this individual was being asked to exit the vehicle because the officer felt best to further investigate, based on the statements that were made, that the defendant was driving this, or that was drinking prior to. He felt that it was best that he further investigate just to confirm that he would be able to let this driver go and continue driving. This is a highway. It's not, you can't let a driver go without further investigating. If they could possibly be intoxicated or under the influence of something, that would just be a danger to everyone. And furthermore, yes, there were standardized field sobriety tests that were conducted and that were passed. However, everyone does hold their, I'd say everyone does handle their liquor better than others, or alcohol better than others. So whether he passed it or not, it could just be someone holding their alcohol better than someone else not. And as to the PBT or the further investigation, I believe the officer stated that the individual, there was some back and forth about PBT being requested, and that's why, again, the investigation was continued. We do believe that we did show enough to keep this case going, and if not, again, it's a misdemeanor. So if we believe that there could be a question posed for a trier of fact or for you, Your Honor, at trial. And based on everything that was heard today, we are asking that you deny defense's motion. Thank you.
Your Honor, one thing I want to say, Madam Prosecutor says they don't have to show how long the vehicle was there. But again, this is a legal question. It's not just that they have to show that he was operating. They have to show that he was operating while intoxicated. And so that's the thing. That has not been shown. The circumstantial evidence in all the cases that have been put forth on this record, even the one cited by Madam Prosecutor, the circumstantial evidence that was in those cases, Your Honor, was far greater. Here we have nothing except Officer Shields admitting there were no signs of impairment. And so we have to go with what's on this record. That is a legal question and not a question of fact for a trier of fact. So we're asking that Your Honor grant our motion.
Okay, so I've heard, I don't need to watch the video unless someone wants me to watch the video. So I've heard testimony from Trooper Shields. I've also heard legal argument and reviewed several cases from the Michigan Supreme Court on down regarding operating while intoxicated. We have here a case where an individual was parked on a board on the freeway. The vehicle was running, but the car was in park, and it appeared that the defendant in this case, Mr. Harris, was sleeping. And an officer Officer Shields and his partner, Trooper Elia, performed what arguably was a Terry stop, right? They stopped the vehicle or pulled behind the vehicle because they have reasonable suspicion. And the trooper testified that the location where the vehicle was parked is what gave him the suspicion. So he approaches, this is a rendition of basically what I've just heard. He approaches the vehicle. He makes contact with Mr. Harris. He indicated he smelled intoxicants, but he requested that Mr. Harris perform field sobriety test, and Mr. Harris passed all of the sobriety tests. He testified there were no indicators of impairment based on all of these field sobriety tests. He testified he then called for a PBT, and it might have been 7 to 8 minutes that Mr. Harris was detained prior to that PBT taking place. And at that point, it's this court's view that the reasonable suspicion for the stop had concluded. He had taken field sobriety test. He passed the field sobriety test. There's been statements on record, I'm not reviewing the camera, but you're both officers of the court, that he indicated at one time to his partner, like, we don't, have anything. He's passed the test, yet they continue to detain Mr. Harris so that they can perform a PBT. The officer testified multiple times in multiple different ways. that he wasn't slurring his words. There were no indications that he was intoxicated whatsoever. The vehicle was in park. It wasn't in a situation where it would cause immediate injury or immediate risk of collision as outlined in Pomeroy and later in Wood. After that, and the testimony is that essentially one statement was made that he had had a drink earlier. And that was the statement that was made prior to the PBT, prior to the arrest. And that was one statement that he'd had a drink at 8 o'clock. This is near midnight when the stop occurs. And after that, after the PBT, he's arrested, detained, Mirandized, and a statement is taken at that time. But if the Terry stop went too far, and the Terry stop kept an individual at a scene after the reasonable suspicion had been cleared in order to effectuate further testing, anything that occurred after that would theoretically be or legally be fruit of the poisonous tree, right? So then what good does this Mirandized statement do for the prosecutor when the statement was made after Mr. Harris had been unreasonably detained under Terry and its progeny? There was no reasonable suspicion at that point when the PBT occurred, and he should have been released from the scene based on that. And I mean, whether or not, you know, the fact that he later has a positive chemical test or a data master test, I'm not looking at the end result. I'm looking at how did law enforcement get there? And that Terry stop went too long because the reasonable suspicion was dissipated according to the officer's own testimony. So anything that happened after that point, it's this court's opinion, would be fruit of the poisonous tree. And the motion to suppress is granted.
Thank you, Your Honor. Thank you, Your Honor.
Okay, we're all set.
Thank you.
Thank you.
And now, I have another iPhone in the courtroom. Can you tell me your name? Ma'am, we're still trying to, I don't know where Mr. Reese is. I don't know if Mr. Gazicki's met with him. He keeps coming in and out.
Yeah, he had a poor reception. He had to leave his grandma's to go find Wi-Fi.
He's here now. Did you get a chance to meet with him, Mr.
Yeah, but I
Gazicki?
got no prosecutor here.
Miss Louise coming back after lunch, I assume?
Yes.
I guess we'll have to do it at 1 when you're next door. I don't know how that works, but.
Well, Jeff will be here.
Okay.
We can work it out.
All right, the prosecutor left for lunch. She's due back at 1 o'clock. So you can stay tuned you can stay with us for 8 minutes. And when she comes back, we'll get you in where you need to go, or you can log back in.
Okay.
Okay, but as soon as we get her back, did you talk with him already?
I told him to wait because I was hoping to find a prosecutor. I thought she was doing the right
No,
thing.
it's Miss Louie.
Yeah.
Okay,
Yeah.
all right. I'm gonna put you back in a room, Mr. Reese, so that.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?